Your Lordship, in spite of the payments made, Your Lordship had ordered for coercive steps against the director of the companies, Your Lordship. We have made the payment as ordered by the controlling authority, Your Lordship. Your Lordship, the certificate officer has not. Your Lordship, not yet. Your Lordship, the certificate officer has not yet completed
Let the law take its own course.
Your Lordship, the certificate officer has not yet calculated the certificate amount, Your Lordship.
Very well.
It is still pending under
Let us,
for
madam,
adjudication,
what
Your Lordship.
But yesterday I mentioned, just to remind your Lordship, I mentioned those two matters yesterday which were there in the upgraded, my lord.
I have indicated to them. They will appear. Upgraded
It
matters
not appear, that is why, my lord.
No, it will appear. It will not appear the next day. It will appear. Entire month is there. Upgraded. It will be appearing.
So
I'll accommodate everyone.
So shall I hand over?
Whosoever has mentioned yesterday, those matters will be taken up, sir. Will be accommodated in course of this month. Entire upgradation.
That item 15, my lord.
If you have mentioned yesterday, I remember. So you need not mention today.
Business has come to an standstill.
I will take it up.
Matter, your Lordship has
I'll
already.
take it up this month.
Great.
I have provided, you see, I am having cooperative determination.
Yes,
So
yes.
I am taking up one day, I'll give upgradation. Thursday, this Thursday, certain upgraded matters will come up. Next Thursday, certain upgraded matters will come up. That is how I'll do it.
Thursday.
This Thursday, because considering the fact it was mentioned yesterday, I've put it on Thursday.
So today, number of upgraded matters is appearing in the supplementary list.
Those are diary matters. No, those are different matters. Yes, call the list.
My lord, I am appearing for the petitioner. My lord, it is for correction.
What is the correction, madam?
My lord, the assessment year is to be recorded as 23-24.
Where, which paragraph?
My lord.
Yes, paragraph 1, then only one paragraph. No, there may be others. You must have find.
My lord, I'm just giving.
First paragraph, sir.
First paragraph, my lord. Only the first paragraph.
No, there must be another place. Only one paragraph, madam.
My lord, only one paragraph.
Are you sure?
Yeah, yes, my lord, I have seen it. It's just the one paragraph.
Only I have seen only one paragraph.
My lord, only one paragraph, my lord. Only the first paragraph.
Not put it up for correction once again.
No, my lord, it's just the one paragraph. The first paragraph.
It appears that in the order dated 27th of March, yes, next.
My lord.
My lord, I'm for the
Yes,
My lord, I appear on behalf of the private respondent. My
yes.
lord had on the last occasion given me an extension to file an affidavit, my lord. My lord, this affidavit has been affirmed, my lord. With the leave of your lordship, may I file this, my lord? The copies of the affidavit have already been circulated amongst the respondents, my lord.
Who's for the petitioner?
I am the petitioner. Yesterday, you have got the remedy in opposition.
Yes, records the stay. Records the stay. WPA 1721.
disclose what we have stated.
My lord, may I file the affidavit, my lord?
Department by good department.
Yes, my lord. My lord, I will file the affidavit on that day itself.
On behalf of
My lord,
It has to file, my lord, with the registry.
Their allegation is nothing was subject to find out what was the signature. If that is not correct,
the next petition.
and third is argument order. That is called statement.
Yes, ma'am.
If we find out
No, no.
the third,
না না বলছে যে ওই অর্ডারটা রেট করে
My lord, kindly give
সাবমিশন
me a chance for 2 minutes, my lord. I would like to.
মানে মে আই বি
I'm grateful, my lord.
ফাইল ঠিক আছে
Or kindly hear me the facts on last occasion.
Yes. But there is a gold loan, or is a paragraph 9 just stated that was personal loan. There's a difference between gold loan and personal loan. The gold loan, gold was mortgage. Gold was mortgage, the loan was sanctioned. That all the gold, there are 21 persons, borrowers. Yes, okay. But that a criminal case has been pending. Criminal charge sheet has been said all are fake gold. That criminal case is pending. But in a similar case, that on Siddheshwar Ghosh, the brother of this petitioner, he also his amount the gratuity that loan amount money that was deducted from the gratuity amount, and so far that
3 lakh.
How much is the gratuity?
but that was 7 lakh something remaining deposited. I said,
But
But-
what the entire amount was
but remaining has been returned has it to his account. Only 4 lakh something. Now 3 lakh 31, that amount 29,000 that has been deducted. Then madam, but I'm
1029.
but I'm
But-
but can you allow me? Can you? But I am citing one decision. I can 59, section 59.
Section 59 will not do, not helping here.
But that
Section 59 will not help you here.
I'm not referring.
kindly see this, but this case, this judgment, our High Court judgment.
Sir, you have advanced the loan as a nominal paper.
No, what is this? There's a member that was the employee. He was the employee.
Sir, it could have been-
But like, I can say, for my satisfaction, for my satisfaction, for my satisfaction. But kindly see, you have also decided. But can you see this judgment of can you see? Okay.
2000 কত? 13 volume 3 CH Cal.
Or can you see? Yes, madam.
No, ma'am.
Very
Mitchell will do that. Mr. Mitchell. Run for Mr. Mitchell. Let him do. Let him. He's more competent.
But section 59 that has been your losses. Can you see?
কিছু বলতে
ও একটা judgment দেখাচ্ছে আমি ওটা বেশি
59 but has power. If there is an agreement, that agreement is there. Bond. Yes, bond is there. But in that document, I have the bond. Yes. If there is an agreement. That is my submission. I may be wrong about this. But that is why I have submitted your promises. All bond, yes, agreement. Why is there an agreement? But that just all the documents, all the bond.
না আমি রেফারি করছি না এটা
Yes, there are several loans. Oh, 5. But can you see? Second page. বাসুদেব ঘোষ আমি প্রতিজ্ঞাপূর্বক অস্বীকার করছি ওই চাহিদা মাত্র ওই টাকা প্রার্থীর সাথে সাথে পয়সা করবো দ্যাট ইজ চাহিদা মাত্র পরিশোধ না করলে গচ্ছিত সমূহ মাল বা উহার আপত্তিমুক্ত অংশ বিক্রয় করে ইদেনার নিকট সুস্থমে আদায় করিয়া লওয়ার অধিকার ব্যাংকে থাকিল উহাতে আমার কোনো আপত্তি থাকিবে না আমি আরো গচ্ছিত মালের মূল্য হইতে দেনাসহ পরিশোধ না হইলে আমার স্থাবর অস্ত্র সম্পূর্ণ সমস্ত সম্পত্তি হইতে ব্যাংকের বাকি প্রাপ্য আদায় হইবে প্রকাশ থেকে যে আমার গচ্ছিত মালের কমি ক্ষমতা ক্ষতি খেসারত এবং সিট করা প্যাকেটের অন্তর্গত মালের জন্য ব্যাংক কোনো রকম দায়ী হবেন না He signed it. If there is an agreement.
May I submit one thing subject to permission of
We are on the gratuity act. How they can deduct it? That's true, but another line. Appraiser on satisfaction gave me loan after mortgage the gold. Either they will hand over me the gold or the money. That's the only issue. Let them hand over the gold.
Our division that has been decided. Unreported judgment.
or gratuity amount.
Because
Even
they also
if
wanted that
agreement.
same thing.
Nothing can be.
File the deed application to return the gold because that loan amount has been deducted from the gratuity amount. Kindly see this division judgment.
In the car.
Siddheshwar goes, the brother, you are the member of this, you are the employee.
Member.
Yes. He also told by mortgaging the gold. Yes, Mr. Sahana appeared. And that criminal case is pending. But charge sheet, but I have submitted the charge sheet. Yes, yes, my lord. Kindly see, my lord. Paragraph.
Issue was completely different
Two.
in that case. Completely different.
The first, my lord,
They did
Number
not
one.
return the gold.
the factual matrix of this case that appellant took loan from the Krishnagiri City Cooperative Bank after mortgaging gold ornament along with others and innocent appellant was unable to repay the outstanding due. According to him, he time and again goes to the bank office to review the amount of outstanding such and such. Then it was subsequently found that fake gold was submitted by the appellant for the purpose of offsetting the loan from the bank. Outstanding loan was deducted from the amount of gratuity.
Issue is completely different.
No.
Yes, yes.
Here there is nothing.
Here there is no complaint, no
Nothing.
charge sheet, no FIR.
No charge sheet. Can you read the charge? Here number 21. Yes, submits everything.
And
FIR.
let my learned friend show a single piece of document that the gold has been seized by the police authorities. And your lordship impose cost upon it.
Same.
Their case is that gold is not with them. Let them produce a single document showing that the gold has been seized by the police. I shall be out of court, your lordship impose cost. Gold. Don't. What I'm saying, my lord. Nothing has been happened so far this case is concerned till today. Subject to your lordship consideration, their case made out that entire gold has been seized by the police. Today I am coming before your lordship either to hand over the money or the gold which I have given to bank.
2021, Siddheshwar gold.
What about the gold?
Judgment of the Siddheshwar
Does it appear, my lord, that
gold. 21. And that charge sheet has been submitted because of division bench.
Page number 20.
what I am paying before your lordship, so far the gold is concerned, that is still custody of the bank? That is still custody of the bank.
No.
There is no piece of document that showing that the that a gold has ever been seized by the police. You took the money, but my gold has never.
Everything has been, the division bench judgment.
Let your file admission show that gold has been
Yes.
seized.
Yes.
I have no idea about this criminal case. Criminal cases, no, I should have. But my instruction is that, my lord,
Now he's-
gold has never been seized. Gold is with the bank. You have taken the money. Hand over me my gold. This is my gold.
Amount has been
Then the division bench judgment.
That is
Yes.
sufficient.
Division
Gold has
bench
never been stolen.
The matter is pending.
Maybe. Where is the gold? Gold has never been seized. There is no piece of document they can show that the police has seized the gold.
Everything Mr.
The mo-
Maharaj,
the-
IPR people
Are Baba,
submitted. He submitted. In spite of that, his writ application was dismissed. And yes, the bank cannot return back. The entire matter is pending.
Gold is with you. It is under your custody. I have taken money by mortgaging gold. You have returned back the entire money 4 times. Now you should have handed over the gold to me. There is no whisper in the charge sheet or anywhere that gold has been ever seized. I will be out of court. Let me
All are
try-
fake gold. Appraiser when they decided to sell the gold, the appraiser submitted the report. All are fake gold. Thereby FIR was lost. The charge sheet is submitted. FIR. FIR. That's it. That's happened. Yes, no. This is original. Original charge sheet, original FIR.
এফআইআর কপি আছে একটা দেখো এফআইআর কপি আছে এফআইআর কপি আছে দাও একটু দাও আমি একটু দেখি জাস্ট একটা লাইন দেখবো এফআইআর কোনটা একটু দাও আমি একটু দেখি মাই লর্ড No, no, I am asking only one question to myself.
Yes. Yes. There were a page 9 that division bench judgment. But a page 9.
Kindly come to page 7 of the FIR.
Paragraph 9, you also can read it.
Yes, page 7 of the FIR.
Yes, yes. Rather, you also submitting to the photos, anything. That is why it is my duty, my lord. No, no, everything. I mean, yes, 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 I know, my lord.
Page 7
And it
and
is
8, it
separate.
says the fake gold. This says it is a fake gold. Page 8 of the FIR. Page 8 of the FIR. Of the FIR. FIR. Charge sheet. You'll also kindly take up the charge sheet. First paragraph, last 4-5 lines at page 8. My lord. Yes. My lord. Thereafter, why? What I'm saying, they never says, they says it is a fake gold. Let this fake gold be handed over to me. Let this fake gold be handed over to me.
Yes.
No. No. But that's the same issue with the division bench. And you see what you get also can. Oh, yeah. I remember something.
Maybe given 1 day or 2 day time, my lord. Because so far no, first submission before your lordship, they have deducted the money from the gratuity amount. Under the Gratuity Act, it is not permissible. Kindly take note of this. Under the yes, yes. All right. Today these facts are before your lordship. What is the fact? Ultimately, they found these are all fake.
Without considering the judgment pronounced by the
Supreme Court judgment.
nothing can be attached from the pension account as well as.
Can it be taken up by the day after tomorrow? Just no. Why I'm saying my learned junior says same issue upheld by the Supreme Court in another matter.
Nothing can be attached.
Absolutely.
From the pension account.
Just give me 1 day. Tomorrow. Make it tomorrow.
Nothing can be attached from the pension account.
Tomorrow.
Even if there is a
Tomorrow, day after tomorrow, subject lordship. No, he says it matter went up to the division bench, writ petition file. Matter ultimately they preferred an appeal before the Supreme Court. Possibly my learned friend is very much clear.
After that. No, that is the one judgment. After that.
And Madan Mohan.
He is suppressing the facts. Yes, Madan Mohan.
Madan Mohan. Madan Mohan কে আমরা জিতেছি সুপ্রিম কোর্ট পরিষ্কার।
Has filed.
Lost.
Lost. My instruction. Then
No.
another. Just give me 2 minutes time. SLP dismissed. Madan Mohanty, one matter, same issue. Same FIR. Quashed by the division bench. They went to the Supreme Court. Supreme Court dismissed their SLP. My learned friend, he was also in this matter. Same issue in what?
Yes.
No. What I'm saying, same bank, same employee, same charge. Matter went up to the Supreme Court. Supreme Court upheld they have given the money. Let my learned friend produce the all documents. Why I'm saying? Because SLP dismissed without any reason. Correct. So we can open that point. If there is a other judgment by the Supreme Court on the self-same issue, division bench also in that matter in favor of the petitioner passed order. In that matter, Madan Mohanty, my learned friend also appeared. That document has not been placed before lordship. Now I can remember my learned friend also appeared. Division bench upheld that order. They went up to the Supreme Court.
After that, this division bench judgment. And Mr. Sarai submitted everything, all the judgment before the Supreme Court. I can show all the papers. I will supplement every, I submitted every document.
Just give me 1 day time. I bring the judgment of the Honorable Supreme Court and the division bench. I shall place before your lordship. If it is concise that your lordship cannot go through the same, your lordship dismiss. Possibly. Why I am saying so? Identical issue decided by the division bench in favor of the petitioner. Bank preferred an SLP.
Dismissed.
That has been dismissed. So division bench judgment in that matter upheld. Today, by the lordship, kindly consider if the different issue is brought up before your lordship on the same point, which will be accepted by your lordship. Just give me 1 day time. Just yes, your lordship. Let I place that judgment just for my satisfaction. The division bench it will be accepted. Division. এটা ডিভিশন বেঞ্চ ডিভিশন বেঞ্চ ডিভিশন বেঞ্চে আমি নাম্বারটা এটা নয় একটু দাও নাম্বারটা আমাদের ডিভিশন ঠিক আছে এই নাম্বারটা তুমি
Hello, Mr. Shah, everything submitted by your supplement affidavit. Mohan Maiti and Supreme Court SLP.
give me one day time
By
just one day my lord
That is all the Alex.
just I'm praying before your lordship let I go through this judgment my lord, no I have forgotten those parts my lord. I have forgotten give me one day time if I do not find anything I shall come before your lordship and say that dismiss the requisition tomorrow
Mr. Shah
Tomorrow.
submitted by your
I have not gone through it for that reason for just give me my lord because Supreme Court judgment is not before your lordship
that they are submitted. By a supplement is serious of those matter.
কাগজই দেয় না কিছু না
Nobody doing after going through everything. Can you see the annexures?
yes
That SLP is in this. Mr. Shah has submitted.
আর মিস্টার সারা একই কথা বলে যাচ্ছে এটা কি মেরিট বেড়ে যাবে তোমার এক কথা বলে যাচ্ছে সকাল থেকে মানে ডিসক্রিশনারি পাওয়ার মানে I just want to go through the Supreme Court order. Just go through. For that reason, I am paying for one day time. The Supreme Court order possibly not properly dealt with. Definitely, your lordship can send the matter to the Honorable Chief Justice for proper assignment. If the points are same, a division bench passed an order, other division bench did not pass the order.
But then in the division bench, that SLP was submitted that supplement. Oh yes.
The matter is over.
Oh. Why get by the original?
Client,
Why get by my original document?
his client is present.
Why get by the paper?
Absolutely. For all. This is for all. When your lordship decide,
Original
Hey,
separate role.
what you agreement?
Previously same role.
My original agreement. All. No, original bond is of that handed over. Oh yes.
Yes, sir.
These are two.
I had it.
What can we say?
And may I leave, my lord?
Yes.
Charge by as I get it zero, then I said, if I just now.
এখানে আছে
Banks may not acceptance of the vote, releasing millet gratuity.
My lord, the item number 4.
In item number 4, my lord, I am for the. Yes.
My lord, may I request your lordship to use the microphone?
Yes.
My lord, item number 4, on last occasion, your lordship has directed them to produce the entire records.
Records, my lord. I will, just a minute. Let me go through the order first. So I'll
Yes.
know what order.
Yes. Now I'll take only 10 minutes before your lordship go through the records. Yes.
First, let me go through the order, then I'll go through the.
My lord.
Yes. Why did you show me only one thing? When did you conclude the inquiry?
Yes, my lord.
And applied in the year 2025, I've seen that. When did you conclude that inquiry?
My lord, from
Yes, Mr. Yes, Mr.
My lord, I just before the records. My lord.
Hand over to me. Find out and you'll hand over.
Yes. My lord, if your lordship kindly see.
You put a sticker on that.
Yes,
and
my lord.
Yes, hand over. Yes, Mr. Sinha.
My lord, first thing I want to show your lordships is the letter dated 8th of August 2024, by which I was asked to
28th of August.
8th of August, that is at page 90 of the writ petition.
Yes.
By the said letter, I was asked to appear for the inquiry on 9th of August, next day.
Page number?
Page number 90, Annexer P11.
Oh, it is actually 8th of August, not 28th. I've recorded.
No, 8th. I said 8th. Yes. 8th of August, by which I was asked to appear on 9th of August. My lord has seen that a better copy is typed out in the next page.
Yes.
Yes, my lord. Now, my lord, I prayed for time in the next page. Well, I prayed for time, and that is why they gave me time till 28th of August. Till 28th of August, that's it. page 92.
Yes.
My lord, now, my lord, come to the inquiry report at page 133.
Yes.
Just a minute, my lord.
Yes. Inquiry report is not 133. It is page number. It is 100.
Page number.
I'll tell you, it is page number.
100.
Yeah. On the last occasion, it was shown me 100. Correct.
Yes, 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 100. My lord, see, my lord, the first line, inquiry report dated 9th of August. That means it's already decided. They have given me a sham time. Already decided, nothing has been done. Let them show a document that my statement, which has been recorded here, has been signed by me from the records. It's already pre-decided. And they refer another letter dated 27th August, which has never been served on me.
Mr. Sinha.
Yes, man.
No, Boshu. Mr. Sinha.
My lord.
Kindly go through the entire inquiry report and show me, did they consider your representation for the adjournment? Is there any reflection?
Yes, because in the last letter, they have fixed it. When I prayed for time, they fixed it on 28th of August.
No. I couldn't make myself clear. In the entire inquiry report, is there any reflection that your adjournment application, is it recorded?
Yes, sir, it's recorded.
Where? Show me that. Show me that. He has nothing to say. Yes, sir. Where is it recorded? Only, I'm not asking you to submit. Show me, if you have read the inquiry report entirety, show me that it is recorded. His adjournment application, factum of adjournment application is recorded.
Tag in pink tag H.
In this, Mr. Rai, you have read the inquiry report, both of you?
Yes, my lord.
Please tell me from the inquiry report whether his factum of adjournment is recorded there.
My lord, in the second paragraph of the first page of the inquiry report.
Yes.
Page 100.
That is it. This is what I wanted to see. Is it your case, Mr. Rai, some report was prepared by you on 9th August 2024?
No, my lord. It was not a report. Those
What was it? What was it, Mr. Rai?
It was only minutes.
Where is that minutes, Mr. Rai?
That is in pink tag H. It has not been annexed in the writ petition, my lord. It is in my original.
Was it disclosed to him?
Yes, my lord. He has signed it.
Forget signature. Was it disclosed to him?
Yes, my lord.
How? A copy was given to him?
My
Tell
lord,
me very clearly, Mr. Rai. I'm not, you are my officer. It's not a jugglery of words. Tell me, I know he must have signed, he has gone there. Was it supplied to him along with the report for him to give his response? Yes or no? He had attended the entire inquiry proceeding. So no required report is necessary to be served on him. That cannot be the case. Was it supplied to him? Yes or no? Show me. Which tag? K?
H.
H.
Tag H.
H. Very well. Let me go through the same. Wait. You have no one in court, Mr. Sinha. You cannot go through the records.
My lord, Mr. Dotto is in the court. Mr. Dotto is in the court. My lord, sorry that I cannot appear personally
That,
because of.
not personally, because you see, this is an inquiry proceedings. Yes,
Yes,
produce.
yes, I understand.
You
My lord,
have-
my difficulty is because
that.
of the. My lord, the lordship knows perhaps that because of the.
Why? What you have disclosed? This is only an attendance sheet.
My lord, it's previous page. The previous page that has not been tagged. That's previous page. Which was also headed as inquiry report. And my lord, page 92 of the writ petition.
This raises serious doubts. Why will you record our attendance as a report?
My lord, this may be. My lord, this may be some erroneous nomenclature has been.
Then he does not know anything about it. Then the gentleman does not know anything how to prepare a report.
My lord, it is the page
He was
which has been tagged as H, and the continuing page is not at all a report. It was practically the minutes for that day's proceedings.
What is the charges against him, Mr. Rai?
My lord,
Yes,
the- from the inquiry.
there are three charges. My lord, as an accountant in charge, I was appointed as a computer assistant, which is a group C post. But since there was no accountant for a stopgap period, I was directed to look after the accountant in charge, as I am a graduate in commerce, which is the required qualification. My lord, that's a group B post. Subsequently, I was again demoted before the proceeding. I was again demoted as to look after the godown, which is another group C post. So punishment I have already suffered. There is no promotion. But so far, these things are concerned. The charges are that as an accountant, I should have been more cautious.
Your explanation that for 4 years you were waiting.
My lord,
Those are in the records
Yes.
4 years after issuance of the charge sheet. And then
What
the
happened?
voting inquiry.
What happened?
Well, those time was spent for selection of inquiry officer. Well, first, after the charge sheet and after considering the reply to the charge sheet, the society has approached learned inquiry officer Mr. Horish Chandra Talwar on 26 June 2021. No, firstly on 27th November 2020.
Yes.
Then reminder was my lord, the letter dated 27 November 2020 has been marked as tag D.
Yes.
Then, my lord, a reminder letter was required to be given to him on 26.
Where is your very well? Where is your response, Mr. Sinha, to the inquiry report?
the inquiry report response I have given.
We have not yet received such response.
You have not given any response to the inquiry report.
My lord, I have asked for 3 documents: the bylaws of the society and the bank statement for the relevant period, which I have no access, despite being the accountant in charge, and the another document. They have never given.
Anyway, Mr. Rai, if you saw, I have said that I will not hear you any further. You will utter one more word. You stop this practice. Previously also I've seen you. Please wait.
My lord, they are more interested to proceed against me, my lord, without showing any interest to realize the money which has been siphoned from the bank to someone else's account.
Sina, that is an entirely different issue.
My
This
lord.
report was prepared on 28th of August 2025 and
Yes.
it was served on you very recently
Yes,
after so many months.
my lord.
Where did you seek for these documents?
My lord, that's
Where did you seek for these documents?
my lord, in the letter of Mr. Dotto, it has been mentioned, and previously it was also mentioned when I replied to the show cause notice. And in my before the inquiry officer also, I told that those documents were never given to me.
Where have you said that?
My lord,
Is it recorded in the inquiry report? By letter, did you ask for these documents?
yes, my lord.
Where is that letter?
My lord, I am showing. My lord. When I am just seeing that whether he has recorded in the inquiry report. My lord, my lord, he has not recorded that, but in my letter it is mentioned.
Where is your letter?
I am showing.
Where is reply to your show cause? Reply to the show cause? Page 78.
It's 78, my lord.
Well, at page 78 is actually reply to the charge sheet.
Very
Yeah.
well. কেউ নিতে পারবে তো? দিতে পারবে তো? আগের দিন প্রীতম খুব গন্ডগোল করেছে।
And reply to the show cause is at page 57, where I asked for the document specifically. Page 57, 1, 2, 3, 4. 3 documents. Page 57. Following documents. Date of appointment of the special officer appointed for which you have quoted the word yes.
Page 57.
Page 57 of the
Page 57 is 13 June 2020.
yes, ma'am.
Then where is the show cause?
Well, at the show cause dated 14th May 2020.
Where is that?
Page 48.
Page 48 is the show cause.
Yes, sir.
Yes.
You sought for these documents.
Yes.
The receipt of 48. In page number 56, you sought for these documents.
My lord.
57. 57, you sought for these documents.
Yes.
Now, did they supply you with these documents?
No, not yet.
They did not. Thereafter, they issued a charge sheet.
My lord. And
Wait.
in the reply to the charge sheet also I mentioned.
Show that. That is very important. Reply to the charge sheet is at page 78,
My lord,
correct?
my lord.
If I'm wrong, correct me because I will hold, yes.
Yes, reply to the charge sheet.
Said so, that you have not been supplied these documents as yet.
No further time would be provided to. However, prior to this, you gave show cause notice to me. In reply to I gave my reply, but the result of those replies have not been intimated to me. And quotation on the section.
You did not raise that issue any further. You did not raise that issue any further.
No, my lord, in the charge also, in the inquiry also, I told that document have never been supplied. And
Where-
I have,
Where have you said that? How do I know you have said that?
they might not have recorded it, but I have told.
Then you ought to have. But what? Very well. You complete it, then I'll ask him.
My lord, if your lordships come to the rule, my lord, cooperative society rule.
Will come later. First of all, you have to show me that you were vigilant enough.
My lord, I was never suspended and I was still working there. And suddenly they gave me the charge sheet. They started the proceeding after 4 years. My lord, and from the inquiry, my lord, certain statement has been recorded, but which was never been shown to me that this was my statement and it was never been signed by the petitioner. In the normal course of proceeding, any statement recorded has to be signed. You lordships had the vast experience in the suit matters. My lord, the witnesses' evidence has to be signed after that.
Statement recorded.
My lord, he has mentioned that Mr. Modi said so and so, submitted so and so. That has been never shown to me and signed by me.
Which paragraph?
My lord, in the inquiry report.
Yes.
My lord, let me place. Page 100. My lord, if your losses come to page 102, when asked by the inquiry officer regarding the preparation of accounts for the financial year 2017-18 and 18-19 by Sri the then accountant in charge, and put his signature on the said cash account, trading account, profit and loss account, and the balance sheet without bank reconciliation in this regard, Mr. Mohri said that he did not prepare the aforesaid accounts for the financial year so and so, and he further said the aforesaid accounts were prepared by Kollan Broto Ghosh, in whose account the money has been transferred. The then computer assistant, and he was the then computer assistant in the said society, and Baneshwar Das legal advisor of the said society. It was observed that the balance sheet on so and so copy was found to be signed by Sri Muhuri, the then accountant in charge, Subroto Talukdar, the then manager, the chief executive officer, and the chairman of the society, and marked and so and so. Well, these statements were recorded. Well, it was never ultimately signed by me. Whether I said these and all.
Yes, where is the finding of the inquiry officer?
My lord, so far as the signature of
Where is the finding of the inquiry officer?
Well, I can show one document by which.
Now wait. No, you did not show me where is the finding of the inquiry officer. that the charges have been proved? Yes.
It's left vague, my lord.
My lord, at
Is
page
vague.
103, first paragraph, last part.
He thinks. Is
It's a gross. Thereafter, again, the inquiry officer proceeded with factual aspects.
No, this is no finding. No finding has been
his
returned.
personal thinking doesn't matter.
Mr. Sinha, you ought to have indicated this
my
at
lord.
the very first moment that no finding has been returned by the inquiry officer on the charges.
My lord, at page 104, in the concluding paragraph,
Yes.
from 7 lines from top,
In this regard,
In this
inquiry
regard, the
thinks that
inquiry
authority
officer
society
thinks
may
that-
take necessary action.
according to the
And
statement
he has to
submitted,
say that either the charges are proved or not proved. Where is his finding? As it is, no inquiry was conducted. This is the reason you did not disclose it for this long.
no, because
You did not disclose it for this long.
no, my
You were sitting tight on the matter. What were you doing? What were your officers doing with this? Why? What prevented your officers?
let me answer.
Yes, yes.
The chief executive officer of the society was in additional charge of this society.
So he could not
Yeah.
apply the inquiry officer to him, inquiry officer's report to him.
It
Mr.
was,
Mr.
attempted to serve in the month of January, but due to some clerical mistake,
Are August? This is August.
yes, this was in
Thereafter,
30
Puja.
31st of August.
Thereafter comes Puja. After August, there is 1 month. Thereafter was Pujas.
Yes, my lord.
So what were you doing? Sleeping before that period, entire period? You were in your slumber
The inquiry report
because you
was
have seen
updated
this
by-
inquiry report. The inquiry report does not show that the charges have been proved.
My lord,
And
total
my
misappropriation.
lord, another point, my lord, who has appointed the inquiry officer?
Where? Which line? One line. That this. Right. You have been no one. You are a junior member of the bar, but that does not make you a toddler here.
My lord,
You have been doing matters for ages now. I've seen you
Yes.
doing matters for so many years. You are aware what an inquiry officer is required to write. The inquiry officer is not required to give his opinion, but to return a finding on the charges level. Now, if he has not returned any findings on the charges level, there is no inquiry. Nothing is proved.
my lord, I cannot improve upon the
Correct.
facts.
So say so. Be
My
very
lord,
clear.
I can only explain from the facts.
No, cannot explain from the facts.
My lord, I can only place from the facts. Only from page number 103. Where has it been written? My lord, I have not.
Where are
shown
the
it.
charges?
My lord, the charges will appear from the.
Civic charges are there?
Yes,
No,
my lord.
the vague charges.
Charges are
Specific
there.
charges. Article number 1 is at page.
My lord, the specific charge the charge is very simple, very small charge. That as the accountant in charge, he prepared the accounts of the society without having bank reconciliation. That is the only charge.
Then no, article charge number. What are you saying, Mr. Rai? Come to charge number 2. His failure due to negligence, sincerity, responsibility, not befitting his assignment. Where is his finding on this? Not there. Then charge number 3, loss of confidence. Not there.
My lord, it has been stated as per inquiry officer's own way.
No,
But-
sir. It is not so simple, sir. After all, when he acts in his capacity as an inquiry officer,
It's a quasi-judicial authority.
you are aware of this. He has to come within the four corners of the rule of law.
The inquiry report must have to be much more clarificatory in nature.
Now, otherwise, you are going to hold someone guilty. Please understand. This has adverse civil consequences.
Yes, my lord.
Life and livelihood may be lost.
Yes, my lord.
And in a country like India, where losing a job, considering the socio-economic scenario, is a capital punishment or a curse to that person.
Yes,
Because not only he loses his livelihood, his family
entire family who
loses his
depends
livelihood.
upon him.
So
Yes, my lord.
therefore, you have to be cautious while snatching a livelihood of a person.
Yes, my lord. That's why
Correct.
the society
Or
was employed.
even putting a stigma so far as he is concerned. Now, where is your finding? You waited for 4 years.
My lord, I was not the inquiry officer. I was the
Maybe.
disciplinary authority.
Actually, you have to answer me.
My lord,
Yes.
I was the disciplinary authority, and strictly speaking, I am also not representing the inquiry officer. I am
Then I
placing
set
the
aside
inquiry
this report.
report. My lord, I am
And leave
placing.
it to you to take decision in accordance with law.
My lord, so far as the aspect of protection of livelihood
I am
of a
not going
person
that
is
far.
concerned,
Forget that. For the timing, let us stick to the four corners of the procedure, irregularities, or whether the inquiry report can sustain itself.
my lord, I
That
may only
the
place
test-
from the inquiry report.
The tests as are available. As a court exercising writ jurisdiction under Article 226, a writ of certiorari, I am required to see whether the inquiry officer had conducted the inquiry in accordance with law, whether there are procedural irregularities in connection with holding of the inquiry, whether the inquiry officer has been able to hold that the charges leveled against the petitioner has been delinquent, has been proved to the satisfaction,
But that's
and
the
whether finally, after all this, whether you have to further consider that adequate opportunity of representation was available or not.
My lord, may
Or
I make,
is it finally perverse?
my lord, may I make submission in
Yes.
this regard? My lord, the disciplinary proceeding is in its midst. It is in the midway. The disciplinary proceeding has not yet been concluded.
Correct.
It was the case of the petitioner that he wanted independent inquiry, and the society was also
Contemplating that. Contemplating that you are trying to say.
No. I'm not on the basis
Then
of
why you
anyone's
served him with the
contemplation.
report?
My lord, it was the case of the petitioner as would appear from page 86 in the writ petition before your lordship, that he wanted independent inquiry to be held to give reply to the findings of the inquiry report. Now, my lord, this inquiry report has been submitted with the society, which the disciplinary authority of the society has made this inquiry report available to the charged employee to express his views with regard to this inquiry report. Now, if he expressed his views before the disciplinary authority, then the disciplinary authority could have opportunity to consider his views in connection with this inquiry report. But he was having that opportunity.
When this comes to the court for examination and the court finds that a report of this nature, audit, first of all, you had sat over this report for 6 months. September, October. 6 months you have sat over
It
this.
may it be considered for January. At least for
What?
January, because in January, my lord, the inquiry report was made available to
Yeah,
him. but-
assuming I take it 5 months.
Yes,
Very
my
well,
lord.
Mr. I take it 5. You were sitting on the inquiry report for 5 months.
My lord, there
Now,
were
not a
certain
report
factual
and a
developments.
court permit the authorities to proceed on the basis of a non-est report, or if the court finds that a report cannot be sustained in the eye of law, what is the use of permitting them to afford further opportunity to respond to the same? On the contrary, I will protect your interest. I will permit you to proceed in accordance with law, which is more better.
My lord, the latter aspect is much more better, because in that eventuality,
You will get another fresh chance.
the inquiry officer,
A second go.
the inquiry officer may further explain whatever his
No
views might
question of
be.
explaining. Considering this, I will direct you, substitute this inquiry officer, do it, and I'll provide that Mr. Sinha,
My
you
lord.
operate with the inquiry officer. Within 3 months, they will appoint an inquiry officer, decide and conclude the inquiry proceedings.
Yes, my lord.
My lord.
Conclude the inquiry proceedings.
And my lord, whether who has been
So,
my lord, the person appointed, my
Issuance of
lord, when in this case, my lord, lordship kindly see from the records
that means
that the CEO as special officer has appointed the disciplinary authority.
inquiry.
there are
Yes,
two aspects. If the
Inquiry and-
disciplinary authority himself conducts the inquiry, there is no opportunity to give a report, because
Yes,
give
my
a representation.
Yes, my lord.
Because he is going to consider this. That is why a representation is there.
Yes, my
Give
lord.
him comply with all principles of natural justice and finish it off.
Yes, my lord. The aspect of compliance of natural justice from the disciplinary authority is concerned, till the appointment of the inquiry officer.
You will appoint a fresh new inquiry officer.
Yes, my
That
lord.
will take a consent and record by consent of the parties. To that extent, you will appoint a fresh, but reasoning I will give, that is on my own. First part is my own. Second
Yes,
part
my
I'll
lord.
call upon you.
Yes, my
Second
lord.
part I'll call upon you.
A
Otherwise,
fresh learned inquiry officer shall
otherwise
be
he
appointed.
has to go back to him. If you do not agree to that, it has to go back to him. But looking at the state of affairs prevailing,
A fresh inquiry officer, a new individual may be appointed.
challenging,
My lord, may I make one small submission? He could have taken this point in his reply.
yes,
This
he could have.
inquiry report.
But looking at the state of affairs prevailing, I do not think that this would be just and
And
proper.
so far as
Challenging the inquiry report dated 28th of August 2024, which was served on the petitioner by cover of letter dated. Where is that cover of letter dated? Page 100, no?
100.
Served on the petitioner by cover of letter dated 4th of March 2025. The present writ application has been filed. Full stop. In order to appreciate the challenge in the present writ petition, in order to appreciate the challenge in the present writ petition, it is necessary to appreciate the facts leading to filing of the same. Full stop. The petitioner where have you stated what is your capacity? Very important.
Well, was appointed as computer assistant.
Which paragraph?
Well, in the list of dates also you will find.
my lord, at page 41 of the writ petition, annexer P1.
No,
That's
no.
the initial appointment as computer assistant.
It is the petitioner's case that he was appointed as a computer assistant with the respondent number 3 within bracket society with an appointment letter dated 28 July 2014. Full stop. Such appointment was confirmed by an office order dated 21st of August 2017. Full stop. It is also full stop. Subsequently, on 30th January 2016, the petitioner was assigned the role of the accountant in charge. Were you assigned the role? No. P2, what is P2? How did you land up there?
P2 is the accountant in charge.
Assigned the role of accountant in charge, whereupon he assumed charge in respect thereof, pursuant to a respect thereof, and such fact would corroborate from a charge report dated. What is the date of this report? Charge report dated
30th January 2016.
30th January 2016.
Thereafter, the chief executive officer was appointed and he took the charge of the signatory as bank of the bank. That is from page 45.
So he assumed the role of accountant in charge, yet for all practical purposes, Ramchandra Sutradhar, since deceased, continued to function as the accountant of the respondent number 3 till 22nd October 2016. 22nd October 2016, and he had subsequently died on 23rd, as he died on 23rd October 2016. According to the petitioner, he said Ramchandra Sutradhar had never handed over charge of the accountant to the petitioner. Still later, one Abhishek Banerjee was appointed as Chief Executive Officer of the respondent number 3 with a notification dated 23rd May 2017.
And by a letter dated 12 June 2017.
By letter dated 12 June 2017, addressed to the branch manager of State Bank of India, Malda branch.
He became the signatory.
He had Malda branch. He altered the authorized signatory of the bank in his favor and continued to act as authorized signatory of the bank and continued to act as authorized signatory of the bank account of the respondent number 3 maintained with the State Bank of India, Malda branch since then.
That, it is pertinent to mention here, in my lord, that although the CEO's lifespan is 6 months as per the Act, my lord, he continued forever in perpetuity.
Records would reveal, now, according to the petitioner, in around January 2020, a financial scam unfolded in the aforesaid cooperative society, in as much as an amount of rupees 52 lakhs, within bracket 52 lakhs in words only, was found to be was found to have been unauthorizedly transferred from the bank account of the said respondent maintained with State Bank of India to the personal account of one Kullan Broto Ghosh, an employee of the respondent number 3, who is to look after the accounts on diverse dates between April and September 2018. According to the petitioner, at the relevant point of time, the bankers' operations of the petitioner were not looked after by the petitioner, but by the said Abhishek Banerjee. And the aforesaid Kullan Broto Ghosh, who also happened to be erstwhile office stationery and section in charge of accounts of the said of the respondent number 3. Following a complaint lodged on 10 January 2020, following this, a complaint was lodged. Following this, a police complaint was lodged on 10th of January 2020. And still later, on 13th of June 2020, a show cause notice was issued on the petitioner. And still later, on 14th May, on 13th June, no? Your show cause is 13th June or 14th May?
Well, it was 14th May.
Yes.
14th May, page
Yes,
48.
yes. So on 14th May 2020, a show cause was issued. Where a show cause notice was issued, whereunder the petitioner was required to show cause why accounts of the financial years accounts, why accounts of the financial years 2017-18 and 2018-19 were prepared and placed before the authority without considering the statement of account, without considering the statement of the account number 11175355442 lying with State Bank of India.
My lord, may I show one thing from that page? From that page 48,
Not necessary.
49. That his
That was-
signature was there.
The petitioner had duly responded to the said so cause and had called for certain documents.
And also said, my lord, that he was not the signatory and password was never given to me.
A charge sheet was issued. Full stop. Particulars of the charge level against the petitioner would corroborate from the same. Now, particulars of the charge level against the petitioner, as would appear from the above charge sheet, is extracted herein below. এই দেখো পেজ নাম্বার 70 তে আছে চার্জ নাম্বার 1 টা আর্টিকেলস অফ চার্জ নাম্বার 1 এটা বড় তারপরে এইগুলো খুব ছোট চার্জ নাম্বার 2 আর্টিকেল অফ চার্জ নাম্বার 3 ঠিক আছে although the aforesaid charge sheet was issued and the petitioner had duly responded to the said charge sheet. Now, although the petitioner had duly responded to the said charge sheet by communication in writing dated 24th September 2020, the inquiry proceedings did not proceed further. Until proceed further until the time hereinafter mentioned. After a gap of nearly 4 years, after a gap of more than 4 years, after a gap of 4 years, a notice was issued on the petitioner on 8th of August 2020, intimating that the inquiry in connection with the above charge sheet dated 1st September 2020 a notice was issued কি বললাম notice was issued on the petitioner notice was issued by the petitioner by the inquiry officer intimating that the inquiry in connection with the aforesaid charge sheet dated 1st September 2020 shall be held on 9th August 2020 at 11:30 AM onwards at the office premises of the respondent number 3. Records would reveal that the petitioner had records would, according to the petitioner, since the aforesaid, since the hearing date was too short, since the aforesaid communication dated 8th August 2024 was an extremely short notice. The petitioner by letter dated 9th August 2020 requested the inquiry officer to adjourn the hearing for at least 15 days. Full stop. At the request of the petitioner, acceding to the request of the petitioner, the inquiry officer by communication in writing dated 10th August 2024 intimated that the next date of hearing of the inquiry would be fixed on 28th August 2024 at 11:30 AM. Following the above, An inquiry was held. However, the copy of the inquiry report was served on the petitioner. However, the copy of the inquiry report was served on the petitioner by cover of letter dated 4th of March 2025. Mr. Sinha, learned senior advocate representing the petitioner, by drawing attention to the inquiry report, would submit that although the inquiry report was prepared on 28th of August 2024, it took them, the respondents, nearly 6 months' time to serve the same on the petitioner. He would submit that the petitioner was, he would submit that the inquiry was not conducted by following procedural formalities. Although the inquiry officer has purported to record the statement of the petitioner, none of the statements none of the statements of the petitioner have been actually recorded. Although the inquiry officer has proceeded on the basis of the statement given by the petitioner during the inquiry, none of such statements have been recorded during the inquiry proceedings. There is no signature of the petitioner on such statements. He has also questioned the competence of the respondents to proceed with the inquiry after a period of 5 years from the date of issue of the show cause notice, from the date of issue of the charge sheet. Mr. Rai, learned advocate, in the facts noted here above, he would submit that the inquiry held by the respondent, by the inquiry officer, is no inquiry in the eye of law. The same suffers not only from procedural irregularities, but also from violation of principles of natural justice, and the aforesaid inquiry should not be permitted to be proceeded further. By drawing attention to the inquiry report, he would still further submit that no specific finding has been returned by the inquiry officer, and as such, no meaningful reply to the same can be given by the petition. No specific finding has been returned by the inquiry officer as regards the charges leveled against the petitioner, and as such, no meaningful reply could be offered by the petitioner to the same. Mr. Rai, learned advocate, in terms of the directions passed by this court, Mr. Rai, learned advocate representing the respondents, in terms of the directions passed by this court on.
My lord, I am representing the society, not the inquiry officer.
That's point number 3,
3, 4, and 5.
In terms of the 3, 4, and 5. In terms of the directions passed by this court on 2nd of April 2025, has produced the records of this case. He would submit that the delay in proceeding with the inquiry was primarily due to the time consumed by the society in appointing an inquiry officer. Initially, although the respondent number 3 had appointed one particular inquiry officer, but since the said inquiry officer refused, letters are here?
Yes, my lord.
Where is that letter? Since the said
pink tag D.
Since the said tag B is not here with me. Tag B is not here with me. Since the said inquiry officer had refused to act.
Well, that is at yellow tag E.
He is not here. The present inquiry officer, the present inquiry officer has.
Those are in this file.
So hand over to me. You are the present inquiry officer had been appointed.
My lord, in the blue file, my lord, all those papers are in this blue file.
Although Mr. Sinha, although Mr. Sinha, according to him, although Mr. Sinha has questioned the inquiry report and claim the same to have been prepared in a predetermined manner. According to him, the recording made at the first page of the inquiry report, that the inquiry report is dated 9th August 2024, is a typographical error,
Yes, my lord.
and typographical error. Stop, you would submit that the inquiry officer only meant to record that on the said date the inquiry had been fixed.
The inquiry proceedings were started.
On the said date the inquiry proceedings had started, and at the instance of the petitioner the same had been adjourned.
Yes,
So
my
stop. He, however, candidly submits that the aforesaid inquiry report does not, in response to a query made by this court, not necessary for him to conclude. In response to a query from the court, he would submit that although the inquiry officer did not return any positive finding, but his views that the petitioner had been, his views that the inquiry officer thinks that the society may take action against the petitioner cannot be ignored. I have considered the submissions made by the parties and have noted the materials on record. I find in the instant case, initially a show cause was issued in connection with financial irregularities of the respondent number 3. The said show cause was subsequently followed up by a formal charge sheet. Full stop. It is true that the charge sheet did not proceed for quite a. It is true that the charge sheet did not proceed for some time. However, in my view, a mere delay in proceeding with the charge sheet does not and cannot interfere with the rights of the respondent number 3 to conclude these proceedings, especially when the same concerns financial irregularities.
I'm grateful to your lordship.
Be that as it may, financial irregularities. On the aspect of violation of principles of natural justice and procedural irregularity committed by the inquiry officer, and the failure of the inquiry officer to identify and establish the charges, and the failure on the part of the disciplinary authority to make available the copy of the inquiry report to the petitioner immediately after such report was prepared, I am of the view that there is no appropriate explanation forthcoming from the respondents as to why the inquiry report was held back by the authorities for a period of approximately 6 months. Be that as it may, upon going through the inquiry report, it would transpire that the inquiry officer has proceeded on the basis of the statements given by the petitioner. Though statements given by the petitioner, although such statements have been enclosed to the report, the entire inquiry report has not been supplied to the petitioner along with the statements. Where are the statements? Are they there? Was it supplied along with the inquiry report?
My lord, those are from page 105 of the writ petition.
This is the one. High Court's order, 106. Yes?
My lord, the 9th August, it was mentioned as Annexer A at page 101. Then copy of the High Court's order were Annexer B.
Where are they? Where are they?
My lord, at page 101, these were mentioned in the inquiry report, and then those were from page 105 onwards. My lord, 105 onwards are the annexer of the inquiry report.
It would transpire that there is no specific finding returned by the inquiry officer as regards the charges leveled by the petitioner. Only certain observations have been made by the inquiry officer. And on the basis of these submissions made by the petitioner, on the basis of the statements given by the petitioner and the written depositions, the society may take necessary action. This, in my view, cannot constitute cannot constitute a reasonable decision on the charges. First up, in my view, the inquiry officer ought to have decided on the charges leveled against the petitioner. It is true, as rightly pointed out by Mr. Rai, learned advocate representing the respondents, respondent numbers 3 to 5, that ordinarily, when an inquiry report is supplied, a petitioner supplied without the delinquent responding to such report, no interference is called for. However, having regard to the peculiar facts of this case, and upon examining the inquiry report, I am of the view the above inquiry report, which does not give any finding as regards the charges, cannot be sustained. The same, however, cannot be sustained and is accordingly set aside. Full stop. The aforesaid, however, cannot impede upon the petitioner's rights, upon the respondent numbers 3 rights to conclude the inquiry in accordance with law. Having regard thereto, and with the consent of and upon ascertaining the views of Mr. Rai, learned advocate representing the respondent number, register needs to give any
4-5.
register. Is the register? Who's the register? Do you need to give any views? His views is sufficient. 3, 4, 5. I am of the view that liberty may be granted to the said respondent to appoint another inquiry officer. Appoint. না এখানে আরেকটা লাইন দিয়ে দিতে হবে, এখানে একটু ফিরে যাও, cannot impede upon the petitioner's right to conclude the inquiry. ঠিক আছে? Having regard thereto, and noting the objection raised by the petitioner and noting the objection raised by the petitioner to the appointment of this inquiry officer and its request for appointing an independent inquiry officer, and upon ascertaining the views of Mr. Rai, learned advocate representing the respondent number 3 to 5, I am of the view that liberty should be granted to the said respondent to appoint a fresh inquiry officer and start the inquiry from the stage of issuance of charge sheet, and to conclude the same in accordance with law within a period of 3 months from the date of communication of this order, with an undertaking from the petitioner that he shall cooperate with the inquiry officer.
My lord, may I make one submission?
Yes.
Your lordship was pleased to grant liberty to respondent's
3 to 5.
responsible employer to start the disciplinary proceeding from the stage of charge sheet.
De novo from the stage of charge sheet.
My lord, the charge sheet was issued. Thereafter, reply to the charge sheet was
From
also
the
given.
stage of the charge sheet and the receipt of reply thereto by the respondents.
Yes.
I'll include that. He cannot give a fresh reply.
The reply was there to the charge sheet.
Yes. Within 3 months will possible, or 4 months.
My lord, there
4 months.
are certain documents, let it be my 4 months.
4 months
Because witness must have to be
from
examined.
the date of
documents.
communication of this order.
Yes, my lord.
Now Mr. Sinha has come in, so everything will be prolonged.
No. My lord,
With observation
well,
given.
another writ petition, my lord, I will just upgrade that writ petition where the validity of the extension of CEO is under challenge.
I will not go. I have not gone into that aspect.
Yes. That is before us.
Observation direction stands disposed of.
Yes.
there shall be no order as to cost.
Yes, my lord.
No point keeping this alive.
Yes, my lord.
You will get it back
The inquiry
after,
reports must
after
be more
this is
specific.
uploaded. Inquiry of it is not clear,
Yes, my lord.
vague.
My lord,
And
as an officer of
I
the
will
court,
record it. It is vague also. I'll
Yes, my lord.
incorporate.
yes, my lord.
You cannot sustain this report. He
Yes, my
nothing
lord.
can
As an
happen.
officer of the court, I cannot improve upon the facts. As per my responsibility, I can only explain those
Yes,
facts
call
before
the
your
next
lordship.
matter.
Grateful to your lordship.
এটা থাকবে ফেরত দিয়ে দেবো পরে কোনটা
My lord, both
এটা
both
কি
do both those two files are, my lord, containing the original documents.
নো এটা কি মামলা
My lord, one copy of one CAN application is appearing there. That CAN application has been disposed of by an honorable coordinate bench. However, my lord, since this is the original file of the society, my
You
lord,
will
they
get
have
it back
written.
from my office. এটাকে একসঙ্গে রাখো এইটা যখন হবে
My
ওকে
lord,
দিয়ে দেবে
both these two
I'm
files
not
may be kept
recording
together.
that the okay I'll record the originals are hereby returned to the learned advocate. The records are hereby returned to the learned advocate representing the petitioner. You will get it back from my office.
Respondent, respondent.
Yes, my lord.
Once it is uploaded, you get it back.
Grateful to you.
Yes, anything, Mr. Sinha, you want?
No, my lord, he is appearing for the respondent. You said, my lord, representing the petitioner.
Representing the respondent numbers 3 to 5. Yes.
My lord.
Item number 5.
I appear for the petitioner.
Lord, I appear for respondents number 13 and 14. CESC.
Number 10.
It is that matter, my lord, your lordship was pleased to direct the election commission to file a report
2 minutes.
at my lord 2
2
p.m.
minutes. I'll come back.
Yes, my lord.
Yes, you tell just indicate the which matter.
My lord, it is that matter, my lord, where draft voters list or the final voter list were not prepared. And my lord, therefore, your lordship was pleased to seek report from the commission to
No. Yes.
Not prepared.
Yes.
Say that affidavit from the commission. Where
Yes.
is that affidavit?
No, it is under process, my lord. Kindly keep it at 2 p.m., my lord. By that time, it will be passable.
2 p.m.
I know today 2 আজকে 2 p.m. আছে তো নাকি আজকে সারাদিন তো 2 p.m. 2 p.m.
2 p.m.
দেখো মান্থলি দেখো
One property matter estate on item number 28. Which may kindly be.
wait entire day is there let us see all matters shall not be decided in this fashion.
Only one matter is.
You wait here in
Yes.
court. If I do not reach last matter, I will take out. 28 I will take up. Wait.
Yes.
Kindly wait here for the serve notice on the respondent's last matter. I will take up. Wait here. Next matter. Very well. Petitioner,
For the petition.
what is the matter? Who's for the respondent?
Respondent is the state as well as my lord, there is a private respondent.
Very well. I'll come back in 10 minutes. Nobody's for the state. In this matter, Mr. Nayak, find out.
Earlier, Mr. Roy appeared, Pradip Kumar Roy, PK Roy.
PK Roy.
Yes.
Which PK Roy?
Pradip Kumar Roy.
No.
No, Pradip Kumar Roy.
Oh, Pradip Kumar Roy. Acha, Pradip. No. Just ask him to be here. I'll be back in 10 minutes. থাক আসছি
Matter is, my lord, the respondent number 13 took a loan of 15 lakhs from the petitioner society in the year 2019. Till date, he did not make a single paise towards the repayment of the loan. After filing of the writs, he was avoiding the service of summons. Ultimately, the honorable
Writ petition is not for enforcement of recovery of money.
but an order was passed. Order has been passed. Kindly see the order 4th of November 2024. The
Yes.
drawing and disbursing officer is the district inspector of schools. And cooperative society is being a special statute. There is special provisions for attachment of the salaries by the DDO.
Where is your requisition?
Pardon,
Where is your requisition?
yes, that requisition has been submitted
Show
before the
me.
that is at page 46, my lord. And the private respondent 13, number 13 has also filed an application which is pending for modification of the order. Passed on 4th of November 2024.
Last time also he didn't. Have
Yes, he is avoiding the service. He is avoiding appearing before the learned court. His monthly salary is attached from the month of November. But the attached salary is not released to the petitioner society.
Ashok Kumar Mondol.
Pardon, my lord?
Ashok Kumar Mondol.
Yes.
He had appeared
Now,
before this
DI,
court.
yes, yes. Mr. Maiti is appeared. Muktashwar Maiti appeared for the private respondent number 13. Not once, couple of times. And he has also filed an application for modification of the order passed on 4th of November last year.
Yes, what happened to that?
That is pending. He is not appearing. Personal presence of the respondent number 13 was also directed by the Honorable Court. He was present. Therefore, after his personal appearance was dispensed with, and once more, the private respondent number 13 is remaining absent. The DI of schools, that is respondent number 7, is represented online by Mr. P.K. Bhattacharya.
Yes, who is for respondent number
7.
7?
Normally, he appears online.
Yes. Who is appearing for respondent number 7?
Mr. P.K. Bhattacharya.
P.K. Bhattacharya, he appears online. crux of the whole thing is, my lord, the salary is attached, but it is not paid to the petitioner society towards recovery of its loan.
Item number?
1122 of the monthly list.
Can want a koi? Can want a koi? Ano, can want ano?
And in this application, he has prayed that his salary is to be attached to the extent of 30,000 per month. He is admitting the default.
Where is the application? Ano, can want ano? List আছে can want.
Kindly look at the prayer, my lord.
Well, allow this application.
This no, Mala, I have objection because the head teacher is going to retire on September 27. And if this 30,000 is paid per month, then the dues will not be recovered. Or his pensionary benefits can be attached. That way it can be done. His pensionary benefits can be attached.
For the time being, I'll modify the order.
Modify by, yes, and to release this amount to the cooperative society.
Yes, I'll direct that.
Yes.
Let them not appear, but this is what is their prayer.
Yes. But at the kindly, for once, my lord, kindly come to the petition at page
He
30.
says so that he has admitted that 30,000. What are your dues?
On the date of filing, it was 21,20,565. That was on 4th of April 2024. Kindly come to page 30 for once.
What is his salary?
This is what it is at page 30.
What is his salary?
Total is 75,213.
He has to survive.
Yes, he has to survive. Nobody is saying that, but he has to pay some amount towards loan.
This is present salary that I do not know.
Yes, this is salary at that time. And kindly come to page 30 for once.
But once he has taken the loan and given a declaration under section 58 of the Cooperative Societies Act, then the employer also will not
becomes liable.
Becomes liable by giving a declaration under
Now,
section
so far as this is concerned, I am not absolving the employer. If the teacher in charge retires, what is difference does it make?
The retirement benefits
Will be paid to him.
He is not the teacher in charge.
He is the teacher in charge, head teacher at the moment.
He is at the moment head teacher.
Kindly come to serial number, my lord. His date of retirement, that is 39/20/27. At the rate of 30,000, it will not be cleared. His dues will not be paid off.
So his provident fund will be
Provident fund gratuity.
attached.
Gratuity can be attached.
Provident fund cannot be attached.
Right, ma'am. But gratuity can be attached under the Cooperative Societies Act. There are judgments also of this honorable court.
other benefits that
Other benefits, gratuity, that can be attached under this act.
So how much will be his gratuity?
That can be ascertained only by the employer or the DI.
that stage has yet to come.
He is saying that he will retire on September.
27. 27.
No, his entire salary is under attachment.
Yes. Because he was not appearing because of his conduct. Because of his conduct. I say, my lord, so far 5 months salary had been attached. Let there be a direction to release this amount to the cooperative society. The petitioner will come.
Will be how much?
3,75,000 something odd. 5 months. And he will come.
Even personally, I inform Mr.
No, the moment it is attached, he is not getting that money.
Right. This is what is strange. He has filed an application.
How the public money can be recovered? That is a big question.
And yet he is avoiding the court.
Both the respondent number 7 as also the respondent number, both the
13.
respondent number 7 as also the respondent number 13 are not Mention the
Yes.
moment the requisition comes, entire file will go there. If you want, I will release the main bit of, it will be easier for you.
Justice Chandra may not be inclined to hear all the matter. Once
Very
more
well.
we will be having debate.
Very well. ঠিক আছে ওইটা করে দাও কেন দাও আর কিছু না মেনের কথা লিখতে হবে না তুমি কেন দেবে ডাকো 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 পরেরটা ডাকো None appears for the petitioner. No accommodation has been paid for. However, to provide one more to appear and contest now, to appear and place its case. Mr. Roy's name be, we are appearing, Mr. Roy, in this matter. And your name should be recorded. ওনার নাম দিয়ে দিও
I am appearing in the 1124 mail. I am for the petitioner mail.
Right for the respondent number 6, cooperative society.
1124.
1124?
Yes, ma'am.
Yes.
Milord, I am petitioner is the expelled member of the housing cooperative society. I am before your lordship challenging the expansion order at 102, my lord. 102.
But before that, my lord, he has to, my lord, establish, my lord, the maintainability, my lord. First, to satisfy your lordship's, my lord.
Wait.
Kindly see the last order
You
dated.
want to go by Temerar?
My lord,
I will hear you first. Not him satisfying. If you want to argue on Demerar, I will hear you
Yes,
first.
no, that
But remember, whatever is stated, you have to accept. That is Demerar. It's very risky.
my lord,
Or else you let him argue and then you respond.
I
Don't
will,
interject.
I just
I
want to,
think
my
it
lord,
will be better. Don't interject. Or else I will give you opportunity. But whatever is written, you have to accept as true and correct.
let him submit.
Yes.
No,
Very risky
but I just
proposition.
make it pointed
Don't
out. Your lordship,
don't make
kindly
any
see the last
submissions now.
order.
Don't make any submissions now. Wait, let me go through.
I will.
Yes.
Yes, 102, my lord.
Yes. Yes, you have been expelled.
My lord, I have not given an opportunity of hearing, my lord. Even I am informed what is the charge against me. Before expulsion, I have not been given an opportunity, and also I have not given a
What
chance.
is this Pets Housing Cooperative Society?
It's a housing.
Housing cooperative society, my lord.
Nothing to do with pet.
No, 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 no. My lord, I have not given an opportunity to appeal before the board, my lord. With the provision is there 112 rule. And the major defect is that
Not maintainability, not been given opportunity of hearing. What maintainability, sir?
My lord,
You have disconnected supply of electricity.
yes.
Wonderful.
that is a
Yes.
separate thing, my lord. That
2
issue
years,
has
my
been
lord.
taken care of
How
by
do
the
you
coordinator
become,
bench.
you have become so powerful
No,
that you will disconnect supply of electricity to a particular flat?
We have not disconnected, my lord. Supply was
Yes.
there. Since his membership was, my lord, terminated,
His membership is terminated, law will take his course. You have to evict him.
that part is over. my
Yes,
lord. That part, if your lordship
Restored?
kindly see. Yes, 100%.
Now you tell me, did you give him opportunity of hearing before expulsion?
Yes, lordship.
Show me,
He has given me, my lord.
show me.
This is his writ petition. He has not annexed, my lord.
You show me,
But
you are there.
It was not.
I
uh,
kindly
yes,
wait,
yes.
sir.
But
That
later
is the
on,
only case.
later on, my lord, that has been done in terms of Rule 133 of the Cooperative Societies Act.
After the expulsion,
Yes, lordship.
that is nothing.
No, no.
Post decisional hearing is no hearing at all.
Rule 133 is the provision of the expulsion. Now, my lord, he preferred the higher authorities, the
No.
appellate forum also.
I have not
Before
preferred,
the
my lord.
state government.
I
The
disagree.
state government had rejected. He preferred a dispute case before the registrar under section 102. That has been rejected. Thereafter, he preferred on the self-same cause of action another writ petition, my lord, that is 9326. But there, my lord, the honorable my lord, coordinate bench has said it's a private dispute, writ petition cannot be maintainable. Again, my lord, clubbing with the that issue of disconnection of electricity, he preferred on the self-same cause of action another writ petition. That is before your lordships. But for that reason, on the last occasion, my lord-
Will you give him opportunity of hearing?
yes, yes, we have, my lord.
You have. Show me.
Documented আমরা file করতে পারবো না। But this point he never raised earlier, my lord. So, my lord, if your lordships kindly allow me, I shall produce the papers. All those papers, my lord, the board resolution and other documents to show, my lord, that he has been given opportunity of hearing. My lord, this is not the first time, my lord. Earlier occasion also, my lord, he was
He
expelled.
may have gone from pillar to post before other authorities. Unless they are superior authorities than the High Court, that shall not stand
I
in
will
the way of
satisfy
the
you.
High Court examining.
I
You
will.
are not you can't satisfy here and now that since a decision has been taken by an authority who is not superior to the High Court is precluded from deciding the matter.
No, I'm not saying that. I'm not saying. I am only.
So therefore,
kindly allow me some time. I will bring all those papers and everything.
so do not give effect to the expulsion in the meantime.
Yes, my lord.
The matter is of 2024.
That has been done in 2018, Lord.
Yes,
This is a case of 2018.
2018.
Right. He is over there. He is residing over there.
He is
But
residing
nothing,
over there.
yes.
Then why you want to throw someone out?
Not exactly, my lord. Lord, he is neither giving bill on maintenance
No.
nor paying electricity charges and other, my lord. There are several, my lord, options, my lord. The state government, when dealt with these issues, my lord, they have
You will not pay maintenance.
My lord, I have paid 2,15,000 and in
How
advance.
much is due on account of maintenance?
as on today, my lord, with interest, what will be the calculation? Not near about 4 lakhs.
To come tomorrow, I'll direct him to pay that. Unless he pays, I'll dismiss his application.
And instead of tomorrow, kindly take
Yes,
it up
yes.
next week, my lord.
Okay, very well. Mr. Bhattacharya, you for this point number 6?
Not I myself, Mr. Raja Shaha. Mr. Bhattacharya is assisting me.
Yes. You are
Respondent
Mr.
number 6.
You are Mr.
Raja Shaha.
Mr. Shaha, learned advocate representing the respondent number 6. On instruction would submit that the petition that huge amount is due on account of maintenance payable by the petitioner. He, however, could not identify the exact figure and pays for an accommodation to place before this court the exact amount due and payable on account of maintenance charges by the petitioner.
But apart from other allegations, there are other allegations.
Forget that. For the time being, let him pay. That will help your society to survive. List this matter for further consideration under the same heading on. List this matter now. Let this matter be taken up for further consideration under the same heading on Mongolbar.
17th.
No, it's a holiday. Tarpore Mongolbar. 22nd.
26th. Grateful.
You bring instructions. And sir, if you think that you will get the blessings of the court for the purpose of ensuring that you do not pay the maintenance charges, you have come to a wrong court.
My lord, my humble submission is they are not raising bills, my lord. Raising the charges.
Now they will raise everything they will produce
they
before
give-
this court and you pay at that amount ad hoc.
My lord, I have paid 2,15,000 already.
Another 4 lakhs you pay.
Yes. If this
He
actual
will bring it. Everything you bring here. I will direct you to pay.
Yes.
Thereafter, I will consider your case, sir.
I have been put to live in dark for 2 years, my lord. It is High Court, Honorable High Court's intervention, and the electricity has been given with the.
Now there is sunshine.
Yes.
There is now sunshine. Lot of brightness, sir.
Yes.
So you should ensure in return that the society does not live in dark.
I shall pay, my lord. I shall pay.
Come back on the next date.
Yes,
Let everyone have the sunshine. Let
Yes.
the sunshine not be limited to you.
Lordship.
Yes, yes. Come the next date. Yes.
Date.
No, point.
22nd. Great.
Yeah,
I am appearing for respondent number 5 and 6. My lord, before my learned senior friend,
No, do not open your case. Unless you argue on the basis of a demurrer application, I will not permit any of the advocates to raise an objection on maintainability. If you raise an objection on maintainability,
maintainability.
then do not make your opinion.
The document has not been properly annexed.
Very
The
well.
proper
Let him place
document
his
has been
case. You produce the document.
annexed. Yes, my lord.
Interjecting is very bad, Mr. Rai. Yes.
For the petitioners, my lord, the petitioners, both, petition number 1 was interested by the board of, interested by the bank, special officer, needed special officer to discharge the duties as in charge of the branch. All of a sudden, the new special officer appointed and some altercation and whatever may be the reason, he has been removed, he has been demoted to the assistant, accounts assistant. And the 16 years junior has been promoted to the post of the, to discharge the duties as branch in charge. My lord, special officer, so cause was issued against me. I have replied that so cause. Second cause, although there is no provision, but second cause was issued, and I have given a reply. And thereafter, pass an order without giving any opportunity.
What
of hearing.
more opportunity you will get?
My lord, I am special officer, want to discharge the duties. But first of that,
Who are you?
Board was dissolved in the year 2017. The tenure was expired. Till date, there is no election, my lord. Secondly, my lord, the special officer should work as per section 36 of the Cooperative Societies Act under the Register of Cooperative Societies. This is special officer without taking any instruction or permission, suo motu issued order for demotion without any fault and without giving any opportunity of hearing. Only so cause on that reply, my lord. I'm reading the provision of section 36. Special officer appointed to manage the affairs of such cooperative societies shall arrange for conduct of election. 5 years completed, question of election does not arise within the period specified in subsection 1 and hand over the management to the newly elected board. And if any elected board cannot reconstituted when the term of the special officer shall be removed from the office of the state government, and thereupon provision of subsection 7, section 29 shall appear for board, nominated board. But nothing has been done. Years after years, they are discharging their duties. Another second provision is with the effect of the date of expiry of the term from the board as cause and such, A, all properties of the cooperative society shall vest in the register and shall remain vested till a new board assume office, and subject to control and
Who is for the
direction.
state?
Subject
for
to
the state?
control and
Yes, Mr. Mitro. Yes.
my lord, subject to
Nominate a
control-
board. Immediately, the board will hold the election. The special officer has lost his force. He is appearing for the special officer.
No, I am appearing for the society.
Society. Now, how can you appear for the society?
bank, my lord, society means the cooperative credit society.
Yes. What is this happening? When last the special officer was appointed? When?
My lord, my pay has been reduced, my lord, on the whims of the special officer without giving it the opportunity of hearing, my
The
lord.
officer has the power to do so.
My lord, the special officer as per section 36 subsection 4 clause B of the 2006 Act.
Subject to control, let me remind the petitioner, subject to control and direction of the registrar, and notwithstanding the performing an appeal under section such, the special officer shall exercise all power and perform all the duties which may under this act or rules or bylaws be exercised or performed by the board or any officer of the cooperative society. That means special officer shall take any decision, can take, but that should be section 36 4B, my lord.
এই দাও তো এই তো বই আছে দাও এইখানে
How the suo motu special officer can dismiss, reduce my scale. Section 36, my lord. 4.
Tenure of the special officer is maximum
6 months. And if it is a financial bank, it is a 1 year. But it is not a financial bank, it is a society, credit society.
Special officer has no power after this period. When was the special officer appointed?
My lord, presently, the same person is not acting as the
And
special
does not matter. How can you continue to appoint one special officer after other? There is no sanction in law. Yes, Mr. Correct. Now, special officer has a power for 6 months. When was the special officer appointed? I'll direct you to take instructions. I'll regularize your appointment. Wait here. Mr. Nayak appearing for register. Mr. Nayak, how can a special officer continue beyond 6 months? 1 year?
It's not a
After 1 year, he has no power.
After 1 year, officer under section 11 without that can be exactly followed on law. 11 is there, it is for protection. That would be thrown away. You are taking advantage of taking support of 11.
No, exemption is from the act itself. Now, are you exempted? Are you exempted?
No.
No, he is not exempted. So,
My lord, the section 11 says
exempted from the act.
My content is different section.
Sorry, wait, sir. Please wait. Let me understand this, sir.
No, my lord. Excuse me, lord.
Society is not exempted.
He says no, Mr. Rai says. Correct.
Exemption of cooperative societies, my lord, state government may appoint special officer by invoking the power of section 11. My lord, here the case was not that. The appointment of special officer was challenged. Had that been challenged, that could have been challenged.
But still then, he now says that the special officer does not have the power. That is under challenge.
My lord, when the order that has been made impugned by him, the special officer was there.
My lord, only my lord can I give it only one minute, my lord. The contents of section 11, my lord, placed before the lordship.
When was the special officer appointed?
Special officer.
Done. My lord.
Yes.
When board was expired in the year.
The board expired?
11 to 2022.
Where do I get it?
My lord.
To manager in charge.
My lord, here is not the my lord.
Correct. No. Today the issue is different. Today an order has been passed. Does not matter. Today an order has been passed by the special officer. No. Which is the order is under challenge. Now I will be certainly required to examine whether he was competent to pass an order. Now, therefore, if he is not there, I will add him as parties. But if he is not competent to pass an order after his tenure comes to an end, statutory tenure, I am not interfering with the order today. But first of all, let me find out whether his tenure has actually expired or not. So that I'm testing out for now. Yes, show me. When did he? When was he first appointed? Which paragraph?
My lord, my respect to submission, since I have not challenging the election matter, that's why I'm not giving that list of dates. I'm praying
Paragraph 12, we have said so.
The petitioner stated that before completion of the inquiry, the Board of Directors to dissolved on 7/3/2022. My lord, last election was
Special
held.
officer took charge on 4th December 2023 again.
My lord,
Now, when is your order?
my order is 25th 5 May 2024.
So this is beyond 6 months. No, within 6 months.
My lord, no, beyond 6 months.
Why?
Special officer took charge on 22.
Please read your amendments correctly, sir. Paragraph number 12 correctly. Please read your amendments. 2022, Special Officer, 7th March 2022, Special Officer was appointed. Thereafter, the Board of Directors, pursuant to Section 36, took charge. And the Special Officer withdrawn on 8th September 2023 and was managed by the highest designated officer of the society up to 29th.
Thereafter again.
So his appointment is fresh appointment again?
Special officer is there. The newly first special officer or second special officer is separate. But special officer is continuing. Special officer is continuing. Special officer after expiry of the board 2022, special officer is continuing. One after another, special officer is appointed, but continuing.
Where have you,
Law does not permit order.
Where have you taken this ground in the petition? Where is your ground in the petition that this order could not have been passed by the special officer since he has already expired, 10 years is expired?
My lord.
Which ground? Where is that ground?
My lord, my ground was separate. That's why I have not stated on that ground. But my lord,
What is your ground?
My ground was there as per 36. Assuming for the time being, my lord, the special officer within 6 months. After board was given expert 2017, we elected 17. 2022 board gone. July 2000 and thereafter 24, that will be more than 2 years in between two special officers are appointed. Still then admitting for the time being, the second special officer is within 6 months. Then my vice officer is as per provision of the section 36 4B. The special officer, although can take any decision for the interest of the society, but that should be under the direction and control of the registrar. What is he has obtained the register that I have been demoted from in charge of the branch to the post of the accounts assistant. What is that order? So-called against false allegation against me, so-called reply was given. Second,
according to you, an order under 36 4B, an order is to be ratified by the registrar.
Or take permission from the registrar. This is going on under. My lord, I'm reading once, only giving one.
I can't find it. I'm asking you, sir, is it your case that under 35, 36 4B,
4B subject to control and direction? Whatever a special officer took place or took decision, that should be.
Who's appearing for the board? You are for the
board. They dissolved in the year July.
Registered. Who's appearing for the register? You are appearing for the register. Was this decision dated 25th of May 2024 taken with your concurrence?
And without my giving opportunity.
Page 68.
65 and 68 for the two petitioners.
Two petitioners.
Two petitioners.
Yes,
my lord. One is a manager in charge and one is a account assistant. Same bank, same thing, my lord.
You want to maintain the petition for which particular person? Separate cause of action.
There is no judicial relationship.
You want to maintain the petition for whom?
Petition number 1. And petitioner number 2 is the same bank.
I'll
same-
grant him leave to file a separate writ petition.
And I'm paying stamp duty for two petitions, my lord, if I'm not allowed. To
The cause of action is different.
No, my lord. Cause of action, sir, in my second petition, cause of action, same, my lord. Same cause of
Your cause of action does not arise out of the same. It is a separate individual cause of action.
Two separate orders, my lord.
No, I cannot permit two to be clubbed together.
Okay,
This
my
is
lord.
not-
In that case, I'm paying leave to file a
Yes.
second petition, my lord.
I will grant you that leave. So far as first is concerned, which page? Page 55.
Page 65.
65.
My lord, this was not the original document which was issued to him. This is an erroneous document. Lord, it is very astonishing where from the petitioner have access to this document, because this document had never been issued, which is at page 65. There
Yes,
was no signature of him.
What is your contention on this?
My lord.
What is your contention on this? Page 65.
Last occasion, my learned friend.
What is your contention on page 65?
My lord. First, my contention at page, my lord.
That this was not
My lord,
reserved,
at page, my lord.
reserved for consideration by the register.
My lord, kindly.
It was not with the concurrence of the register.
No, my lord. My lord, can I page once more, page 50, my lord.
Yes.
60, basic 50. Number 1, office order. Number 1, petition number 1. Who was manager in charge of the society? But here, job allotted the assistant accountant. Then, my lord, come to page 52. Where is Pradeep Das, who is 16 years junior than me? He has been awarded manager in charge. And simultaneously, last effective 65, where my pay has been reduced. And one thing, only my lord, the discrimination is this. I have admittedly, this special
Affidavit of service filed in court is taken on record. I'll hear it. Yes.
my lord, another is discrimination is there, my lord.
Fixation of scale of fees.
And appointment of.
No, your concurrence has not been taken. You show me that your concurrence is there. I will not interfere.
They are saying that
No, they are saying
Yeah, but
he is saying something else. He is saying that having regard to the provisions contained in 36 4B, without your concurrence, nothing could have been done. And so I will direct you to just place before this court whether there is any concurrence or not. The matter ends there.
my lord, another my lord,
Arey, wait.
discrimination, my lord. How have been
That I will not go into that. That's further appealable.
my lord, special officer is granting career
Affidavit of
advancement
service
scheme
filed
for
in court
junior.
today is taken on
25th May at page 65 and another order dated at page 58/4/2024. These two orders I am challenging, my lord. One is demoted me from without any inquiry or giving opportunity.
58 to the
My lord, the
My lord,
order
my lord,
page
50.
50 has not been assailed in the prayer.
My lord, my lord,
And if you, so far as you are concerned, you proceed and give concurrence if you find fit. But for giving concurrence, you have to, it is everything is vested in you.
Otherwise, all aspects, I'm going to come take here.
No.
All what's no those things will come.
Why?
Sorry. If they're taking action, then my lord's obligation. They also.
Naturally, sir, that is the law on the subject.
Unless comes here.
I have only given my prima facie view. I have not decided that. Acha, তাহলে
Page
take
50,
instruction.
my lord.
Well, I'll directly take instructions in the matter.
My lord, page 50, my lord.
Very well. Take instructions in the matter and come back.
My lord,
Last time and deleting that this will not give you power to give the concurrence.
my lord, in order.
Yes, yes. You come and submit on the next day, take instructions and come back. I'll delete that part. 21st? 29th?
Let a copy of the writ petition.
Yes, let a copy.
My lord,
Let a copy of writ petition be served on Mr. Mitro. Yes.
Mr. Mitro means you are applying for?
I had directed Mr. Mitro to take instructions in the matter.
My lord,
To facilitate your matter.
my lord, respondent number I want to know so that I can, in a letter, I can put in the respondent number, the learned advocate pursuant to the order of this honorable court, I am handing over. That's why, my lord. My lord,
May your lordship be pleased to.
ওই শেষ পালটা আমি কাটতে হবে।
My lord, may your lordship be
Please,
pleased
this
to give
matter
it
under
on.
the same heading. Please then let this matter be taken up for consideration under the same heading on 29th of April 2020.
My lord, may your lordship be
my lord,
pleased to
entire order
give
is.
it on 1st May, my lord, on 29th April, my lord, I have some difficulties, my lord.
First may not be taken up.
My lord,
Because-
on any other day. my lord.
Acha,
On-
first of May, first of May, first of May, first of May.
My lord, my respectful submission, my lord, the two ordered to be recorded.
I will record that. But unless you have challenged it in the petition, I will not. You have not challenged.
I'm challenge it.
You challenge whenever you challenge, I will record it.
Then in this order, my lord,
How can it go?
my lord said 25th May order has been, my lord, recorded. And another 8/4.
Where is your prayer to that effect?
My lord, by page 64, my lord.
Prayer.
Prayer, my lord.
দেখি পিটিশনটা দেওয়ার একবার প্রেয়ার দেখি Yes.
My lord, pair D, my lord. 8/4/2024.
Page?
Page 25. Writ petition, page 25.
Page, where is it order?
50, my lord. Page 50.
ঢুকিয়ে দেবো দুটো ঠিক আছে তুমি করে দাও
Two order, my lord, only respectful stuff. 8/4.
না নিতে হবে না কেটে দাও
8/4/2024.
I'll include that. And you have to only take instructions, Mr. Naik, you are only to take instructions. That part I will delete. 36(4), ordinarily that that finding I'll delete. But I'll hear you and then decide it on the next occasion. I'll hear you on that.
The next matter
filed up. Call the passover matter.
The appear for the petition.
I had got for a passover to file the affidavit. Now, it is with the commissioner, my lord. The commissioner has put in some objections, so we could not finalize as yet. Will it be my lord's pleasure to keep it tomorrow so that we can submit or day after?
Tuesday. Tuesday means Thursday.
This Thursday.
Next date. Next. Not today means next date.
Next.
Should have indicated in the morning. They are here.
My lord, we thought it will be done, but somehow.
In the meantime, my lord, I would request my learned friend, the copy may be circulated to all of us. So we can go through and assist your lordship.
Entirely up to you. I'm not passing any orders for the present moment.
Very well, my lord. Very well.
Yes. What further steps have you taken in connection with that election?
My lord,
You have indicated everything.
my lord, I have indicated everything. But I will try to satisfy my lord that.
Thursday.
Perhaps I will be able to show my lord that we have not made any statutory violations.
Let's see.
Oblige.
Grateful.
Grateful, your lordships.
I don't know, 1126, my lord, with the kindly. My lord, I will pay for not this week.
Why Rashid why my learned friend Melody, he sought for time again. Today also he has for time.
What number?
1126. 1126.
The issue involved in this matter, my lord, has already been settled. It is in a writ petition. Against that, my lord, they preferred an appeal. That appeal was dismissed. Again, the self of ground, my lord, another writ petition has been filed. Kindly see the order passed by Justice Sobhasji Bhattacharya. On the sales of cause of action, my lord, can you see? Well, can you see page 80? This matter has been settled. Issue has been settled between the same parties. Page 80. Challenging this order, my lord, they preferred an appeal before the Honorable Division Bench. Presided by Chief Justice. The appeal was dismissed. Well, this must be dismissed with heavy cost, my lord. Order Honorable Division Bench, page 95.
Yes.
My lord, I was going for not this week, my lord. Kindly give me not today at least, my lord. In this matter, I'm led by Mr. Parthapratim Roy, my lord. Kindly give me at least not this, not today, my lord.
The petitioner prays for an adjournment. Now, the instant petition has You wanted go out of this, I have allowed it. No, the bank should not be aggrieved by this observation. I have made the observations. As and when he will move, the challenge will be there. And why is the certificate officer not executing the certificate?
I don't understand this. There is no bar, there is no.
File an application for implementation. No,
There-
it
there
is
is
for
no-
you to take. Here is
There is no rest and order.
it shall not stand in the way, and it is expected that certificate officer, having regard to the observations made by the coordinate bench, should forthwith take steps for implementation of the certificate, especially when there is no impediment in executing the same. Yes. See, counsel for the petitioner seeks an adjournment.
Lordship, item 1127, I'm for the state, Lordship.
What is the matter? On the previous occasion when the matter was taken up for consideration, on
Lordship.
Lord, I am appealing for the respondent number.
You have the petitioner, Lordship.
I am
The
appearing for the state.
petitioner was an employee of the Tapon Cooperative at Dinajpur, Lordship. Lordship, he was, it was alleged that he defalcated some official money, Lordship, of the cooperative, Lordship. They filed a police case against me, Lordship, and also instituted a departmental proceeding against me. And there in departmental proceedings, they proved that I have defalcated the money and directed to be removed from the service without any further reinstatement, Lordship. In the same self matter, Lordship, and the police case, Lordship, I have been exonerated by the Honorable Court, Lordship. And from then, Lordship, I have not given any money from my service, Lordship, as a terminal benefit.
you have asked for reinstatement consequent upon your acquittal.
No scope of reinstatement, my lord, because my age has been superannuated. I reached the 60, Lordship.
Yes, what do you want?
I only seek for benefits from my service.
What
Lordship.
benefit?
The retirement benefits, Lordship.
Where is the order of dismissal?
Lordship, I have annexed it, Lordship, at page P50.
Yes, provident fund you have forfeited.
Everything has been.
Are sir, wait.
Sorry, my lord.
Provident fund you have forfeited.
My lord, in the next page, my lord, it has been written as such, my lord, the provident fund should not be forfeited.
You appreciate that?
No, my lord. As per section 10 of the Public Provident Fund and Miscellaneous Provisions Act 1952, it should not be forfeited.
What about the Code of Civil Procedure? Same thing? Cannot form subject matter of attachment also?
Yes, my lord. But
How have we done this? What is this provident fund? How much?
my lord, that I shall have to take instruction. And an arbitral award was there against him.
And enforce that arbitral award against him. Who is stopping you? But you cannot attach his provident fund.
Yes, my lord. That is the law, my lord.
You know of the law. Then why is the provident fund, Mr. Rai?
May your lordship be pleased to direct for releasing that provident fund.
Along with interest at the rate of 10% from the date it was forfeited till such time it is released in his favor.
And so far, my lord, as other prayers are concerned, my lord, only because of acquittal in criminal case. At page 58, it will appear that prosecution is hopelessly.
I will not go into that. I will not go into that.
My other submission is apart from provident
Yes,
fund.
sir. Complete your submissions on this. You understand what you're going to get. A lawyer knows where the shoe pinches. He knows his case the best. Mr. Rai, he might be placing his case in a manner as if he's entitled to everything, but he is aware what his client will get. So he will not argue any further.
So far as the provident fund aspect is concerned, I cannot stand in the way because of that section.
Correct.
So far, my lord, other aspects are concerned.
I'll dispose it of with a direction to release the provident fund amount along with interest.
Yes.
Naturally.
And Lordship, one more
Yes.
clear Lordship. There is a provision under the old Act, Lordship.
Subsistence allowance you have not been paid.
My lord, those
You
have
was under suspension.
No.
my lord, those have been paid.
Are you sure?
No.
If it has not been paid, you pay subsistence allowance as per your rules.
Hmm.
Your rules provide for payment of subsistence allowance.
That is there.
Calculate it. I'm not going into that aspect. You calculate it and pay him subsistence allowance. You see, till such time he is dismissed, or like Railway Protection Force rules are different. They say that subsistence allowance may be forfeited also. But you have not forfeited the subsistence allowance. See the order?
Yes, the board has also decided that all money receivable by you on account of provident fund and leave salary.
Correct.
Stand for.
So all money on account of provident fund and leave salary. Leave salary you can. I will not go there.
However, my lord, this order was of 2004. My lord, he has filed this writ petition.
Because
only
he says that he has
after
been
acquittal.
exonerated very recently.
Only after, my lord, only after this acquittal, my lord, the findings in a criminal
Stigma
trial.
was attached to him. He could not have come forward.
He has come forward before this court in an opportune moment. Only upon getting
Naturally,
acquittal.
naturally.
Acquittal.
Naturally. He wants, that is why he wants to place his case that give me back everything. He started with that.
Yes, my
He has covered his back.
lord. Yes, my lord. And I was opposing that. That he cannot take everything. Only because of acquittal in criminal case. Maybe on the self-same charge.
Dispose it of.
Yes.
What do you want? Well, I'll keep it pending. No point keeping it pending, is it right?
Provident fund cannot be with.
Correct.
It cannot be kept with it.
Lordship, one liberty may be given, Lordship. If
Who?
I do not approach before the appellate authority, Lordship, they will realize that award, Lordship, from me.
Award also, this provident fund cannot be realized.
Provident fund cannot be.
Even by provident fund cannot be realized. I'll record that. Award, whatever is there, the provident fund cannot be realized from.
Lordship, they awarded 5 lakh something upon me, Lordship.
Awarded
No. They pass an award, Lordship.
in favor against you. You are an award debtor.
Award
You are an award debtor.
Yes, my lord. That is at page 40.
41.
It starts from 40. The operative part is at page 41. They have not challenged it. He has not challenged it in the cooperative tribunal.
Later.
It was passed under the provision of redressal of dispute case.
Let us not go into that. Let me not go into that. You are also not arguing this.
No.
You are not trying to say that since there is an award, you are entitled to recover provident fund from him.
No. That was not my submission.
Yes, so I will not go into that aspect at all. DPW.
Okay.
Next.
In 1129, my lord, I am also appearing for respondent number 5.
কি চাইছো? এনো সেকশন 10টা পুরো সেটা ধরো। তুই না পারলে সোমনাথ আছে, সোমনাথ তো আসবে না, সোমনাথ তো বাবা ওনার জ্যাঠা মারা গেছে। ঠিক আছে, ইন্টারনেট থেকে পেয়ে যাবে তো, এসএসসি অনলাইন থেকে পেয়ে যাবে, সেটাও তো মনে হয় না চেঞ্জ থাকবে, ছাড়তে হবে না।
My lord, I am for the petition.
ইন্টারনেট থেকে এসএসসি অনলাইন আমার পাসওয়ার্ড জানো?
My lord, after retirement of long time, the bank has not paid PF, gratuity, and the leave encashment. Because I'm the employee of the cooperative man. I'm the employee and my lord, my lord, my lord, that was challenged before the Honorable Court in his petition number 7432/24. The matter was appeared before the Honorable Justice Amrita Sinha.
Yes, 34.
My lord, the Honorable Justice Amrita Sinha, my lord, after hearing the parties, directed the petitioner in order at page, my lord, 34. My lord, my lord, how did he determine? Please, my lord, I have returned in the year, my lord, my lord. My lord, in this case, my lord. My lord, I have returned. My lord, I have returned in the month of January 31st, 2013, my lord. If there is any report, audit, so cause, departmental proceedings started against me, whatever may be that within the service period, I have been allowed to retire peacefully, with diligently, and retired it. After my lord, my lord, my lord,
coordinate bench of my lord Justice Kaushik Chando in WPA 2325 of
my lord, I am coming, my lord, I am coming, my lord.
That writ petition has been disposed of on 24th January this year. My lord, that order has not been annexed in this writ petition because that order has happened subsequently. My lord, the Honorable Court has said that in withholding of gratuity, my lord, at page number 7, in the penultimate paragraph, therefore I am not entitled to direct the release of petitioner's gratuity until
এই অর্ডারটা শুরু করতে হবে। অর্ডার কি বলেছে? কি বলবে? এইটা না বললে কি করে? My lord, my respectable submission before your lordship, this order passed when? A writ petition made when? I have not separated anything. This petition was filed as we have complied the order of Honorable Justice Amrita Sinha at page 34, my lord. Kindly look into 34. Kindly, my lord, please 34. My lord was pleased to. My lord. So many, not retirement benefit not paid, that Please, my lord, I'm pleasing. My lord, I'm pleasing. B, prayer B, my lord. A writ Rule 26 of the Rules of the Honorable Court relating to matter of the article of the Constitution to be dispensed with. B. A writ in the nature of mandamus setting aside the impugned order dated 6/2/2024, passed by the Inquiry Committee of the Respondent Bank. Inquiry Committee constituted after a lapse of my 9 years of my retirement. Achha, a writ in the nature of subsidiary column such and such to pass interim order restraining the respondent. Subsidiary calling upon the respondent to certify and transmit the records of the case before the Honorable Court so that considerable justice may be administered to your petitioner by granting relief in terms of prayer given above. To pass an interim order restraining the respondent from proceedings any further in respect of the impugned order dated 6/2/2024 against the petitioner till disposal of the petition. Rule NISI in prayer A to B, any order. In that order, my lord, after hearing the petition, my lord Honorable Justice Amrita Sinha was pleased to direct the petitioner. I am reading, my lord. It appeared that there are several factual issues that are to be adjudicated by ascertaining the legality of the order passed by the bank, my lord. The dispute is between the employer and the employee. It will be open for the petitioner to approach the Register of Public Societies with his grievances and raise all points of law and fact before the said authority. Next page, my lord, 35. The registrar shall take a decision in the matter in accordance with law at the earliest after affording opportunity of hearing to all the necessary parties. It is clarified that court has not entered into any merits of the order passed by the cooperative bank, and it will be open for the registrar to decide all points in accordance with law. These are the order. Pursuant to this order, we have gone to file an application before the Register of Cooperative Societies. My lord, at page 36. The Register of Cooperative Societies, that is Additional Register of Cooperative Society headquarters. In inviting reference to the above, you are requested to approach the appropriate forum in compliance with the solemn order dated 26/4/2024 in the Honorable Court, Calcutta, in the matter of such and such. Entire sets of the documents submitted at this end are hereby returned to you. Then, my lord, I approach to the application returned to me. I have not annexed here. My lord. What have you? So where shall I? Then I man. My lord, award declaring that the action of the defendant, bank. এটা ইন্ট্রোডিউসিং কোঅর্ডিনেটর ছিল না। Another point, madam.
For the registrar,
Another point, madam.
possibly the section 102 bars of deciding any dispute regarding disciplinary proceedings or regarding a dispute. Do not take me amiss, Your Lordship. What I was suggesting is that, according to us, the Honorable Court, we are going to decide it. We have not directed him to go to the Honorable Court. Kindly cease. Appropriate forum, Your Lordship, what the appropriate forum meant for us is to the concerned Assistant Registrar of Cooperative Societies, not to the Honorable Court, Your Lordship. We have
assistant registrar of cooperative societies to assist the registrar in the particular range. In every range, in every district, there are assistant registrar of cooperative societies who deals with the issues in their particular range. We thought it that, Your Lordship, if they make there is a misunderstanding, Your Lordship, in on appreciating the order, the spirit of the order. We thought it can be resolved by way of a representation to the concerned ARCS, Your Lordship. If he makes a representation before the concerned ARCS, we shall disclose it off after hearing the parties within a week, 2 weeks, 3 weeks, whatever Your Lordship desires.
My lord.
He filed a dispute case, Your Lordship. He filed a dispute case under 102, Your Lordship.
Which others?
And 102 debars deciding dispute disciplinary in connection with Your Lordship. Let him approach.
My lord, thereafter, after the receipt of the entire plaint has been returned to me, then we approach to the ARCS concern. Then page at my 37, my lord. With reference to the above subject, relevant portion such and such passed by the Honorable High Court in such and such in the matter. Mr. Asadul Haq versus Birbhum may kindly be read as follows. It will be open for the petitioner to approach the Registrar of Cooperative Society with his grievances and raise all points, law and practice.
Here is also
Correct. You are therefore requested to you are therefore to dispute before the appropriate authority. I am moving from this corner to that corner.
Kindly seize 103 for once. Your Lordship, what happens? This is not with a dispute case. Your Lordship, directs it, will treat it as a representation. He filed it as a dispute case, Your Lordship. Then, Your Lordship, a technical error would have happened that we had. Your Lordship, then please clarify, we shall do it.
My lord, register returned my application with dispute because my lord recorded that is a dispute between employer and employee. That's why dispute filed. My lord, assistant registrar has no authority at the statute to adjudicate. My lord, the one line as per 103, section 103 2.
Cannot be a dispute. It cannot be a dispute. It's a representation.
My lord, my prayer was, I'm moving from ping pong from this court, this register to assistant register. I pray before our chief to direct me. My lord, that has been decided already. That issue has already been decided. After filing of this issue, the matter has already been decided. Mr. Rai submitted. That has been decided, and
nothing remains. Then nothing. Then it has.
That is decided, my lord, in the
nothing remains to be decided.
My lord, in the Honorable Justice Kaushik Chandra, my lord, the compensation, my lord, I will go to register guide been only 103.2. My lord, the director to go to the register.
No, that is different.
No, my lord. That is, no, my lord. Go to register. I have approached the register. No, that is separate issue. Not for compensation. My lord, only what have a note, my lord. My lord, one they have a my lord, only one contention was compensation 50 lakhs. That has been challenged, not the gratuity benefit otherwise, my lord. And gratuity benefit decided in another petition. And the compensation, my lord, director be to go to register. Again, I shall go to register. But adjudicated, my lord.
Fund the funds of 50 lakhs.
My lord. Only compensation for 50 lakhs, not the gratuity, leave encashment and retirement benefit. My lord was directed to go to register. No, my lord, I'm not compensated for restraining the compensation order, my lord, passed by the board. Now, my lord directed me to go to register. At least register can take the representative. That is my praying, my lord.
Please, cause of action public চলে আসবো তো আবার it's a one minute matter because election is fixed. Yes. 1 minute. We have nothing more to submit. Only 1 minute, Lordship.
Item 28. 28 in the daily
Tomorrow there is a resolution that no adverse order in the absence of both sides. So I was thinking my other side is also, they are the ones who are always present. So if I don't finish today, I also have matter going on. So then we can continue tomorrow then. Yes. Lordship will be here. Justice Honorable Banerjee's then tomorrow we can do it. No, not this matter.
Not this matter.
Tomorrow, Lordship, whenever to do. My other side is here. If I can't finish today, then I can finish tomorrow. Today I have a matter. I have to. Yes, that's the hope. I will start them. Other side will be addressing there. So, yes, I'll take.
Yes, my lord. This is it. 28.
I'm following you.
28 daily.
I'm following the 28.
My lord, my lord,
My lord, the original because you are stamping that way.
He is not allowing the lordship to speak.
No, agony.
What happened before the
my lord, in Balaharini, Shambhunagar Balaharini, SKUS Limited, Agricultural Credit Society, SKUS Limited. SKUS Limited, election notification was issued and date of filing nomination was 10th March and the scrutiny of nomination was 11th March. And the fact is this, the election commission allowed the
Cut it short, lordship. May I just with your kind permission? Well, election is fixed on Milord 11th.
11th April.
No, everything is completed. Now, in the meantime, they have filed one dispute also. Our election commission has fixed also Milord 17th to decide that. So, any result, this result of the election will also abide by the result of the election commission. That's all.
result of the election dispute.
Election dispute, Milord, they have raised one election dispute because regarding the membership and all these disputes. Now, Milord, what I am on is, I have taken instruction. Let election be not over. 11. Yes. 11th is the date.
Ground for challenge is this: the election commission allowed the candidates to deposit their dues up to the date of scrutiny. But as per provisions of the West Bengal Code, date of scrutiny was 11th March 2000. I have filed the petition on the before the election commission 26th March. As because there is a defaulter member was allowed to contest in the election, but which is contrary to the provisions of the section 32 subsection 7 E subsection 3.
Apart from that, one dispute was filed, that was decided, that was also not closed. Again, another dispute.
I have filed the dispute on the 26th March, a copy of which is annexed herewith. Kindly look at page 19, yes, ma'am.
11th, day after.
11th, date of election, 11th.
Steps have been taken. Over. Election is on 11th. Now,
my lord, it may kindly be directed to decide the matter on the 10th.
One day is it possible today is 8? That will not disturb their interest, lordship. In that event, lordship, no further notice to be given, lordship kindly fix the. Good. That would be done because small society, otherwise there was a huge problem.
Nothing much of it.
Grateful also.
খালি সিট ছিল
As I was yesterday on that, it is the future possible loss contingent upon that Rule 18 levy being made. That cannot be a cause of action arising within. That it is like service law, pay commission report, recommendation of the pay commission. It is never justiciable. One has to wait for the employer to accept it. That's arises. And also then does not matter whether it was made in Delhi or it's a central, it will be a central law. So wherever you suffer a loss, actual loss, where you can maintain it. That too only actual loss. Say an importer of paints, this whatever ductile, dutile, can maintain it. Can maintain reputation because while importing, he'll have to pay that anti-dumping duty. And importer of motor cars can't file a writ petition. He won't have locals because he may in future venture into paints, and so then there has to be actual loss suffered. So on this recommendation part, service law, as the Lordship observed yesterday, is a different category as when I was placing the disciplinary proceeding judgment. Lordship
without actual loss, there cannot be cause of action for moving the petition.
This is my second point, flowing out of recommendation does not give a cause of action. It has to be actual loss suffered. Because here the central government is fully at liberty, not at all bound by the final finding. They may do what is, there comes the policy. Many other factors which are not economics. Up to Rule 17, it's economics. That somebody is under by, but 18 comes policy. It is like what is happening in the world today. Tariff war, whether it will be a counter tariff or not, it's a policy decision.
Now, Lordship, on the recommendation part, there's one or two more judgments I want to show.
No, if it was purely a policy decision, then there cannot be subject to review. Then no appeal. Then no appeal. No appeal.
No, but then if it's
No appeal.
but if it's a pure policy, but if the economic loss suffered as a consequence of policy, one can file the appeal.
Then the footing of judicial review also comes in.
You can file the appeal, but in appeal, it will be a defense by the state that this is a policy decision, so I can't, you can't check. But the appeal will be filed. So rule section 9C. Now, what will be
that is very clear that the appeal is maintainable. That is a statutory provision provided. So
once the levy is there.
So if it is a policy, then it would not have been an appeal also.
No, but there's an appeal provision is there, of course. But as your lordship knows, in any statutory authorities,
for instance, if a legislature takes a policy decision in a matter, or the government, not the legislature, the government takes a policy decision. Now, policy decision, can it be subject matter of an appeal?
That purely depends on the statute. If there is a provision for appeal, like in let me think of it. Because rule service matter, when the pay commission report is accepted on there may be a government may want to promote one industry. So for one industry, they may accept the pay revision for one type of business. But that will be one of the defenses which will be considered by the courts. But since there's a provision for appeal, will be. But now, Lordship, coming back to this Madras judgment, as of now, there is no.
Yes, that you indicate.
Now, Lordship, two more judgments on this pure recommendation. Pure recommendation will not be appealed to. 2000 volume 8 Supreme Court cases 580. Paragraph 7 and 8. I'll give you mine after I finish. The Delhi guy is not there. Rajesh Sharma is not there. Page 583. Paragraph 7 and 8.
Online. You watch it line? No.
He's not here physically. He's the one who gets everything done.
Sharma is not joining.
Huh?
He is not joining.
He has joined. He has joined. Rajesh Sharma, I find. He's the one who keeps all the judgment. He's the one who's he's an anti-dumping expert. Whichever matter he knows anti-dumping. He's appeared.
He's Mr. Pragyan Sharma.
Pragyan Sharma is the counsel, senior advocate. I see. Rajesh Sharma is the advocate on record. And he does only that. There he is, shown his face. Paragraph 7. The division bench of the High Court allowed the appeal filed by the respondent stating that admittedly the respondent was performing technical duties and was performing more hazardous job. The radio operators in CRPF were not only performing similar nature of duties as that of radio operators of the Central Water Commission or the Directorate of Police Wireless, but they were also performing more hazardous duties. The appellants, appreciating the nature of work, made recommendations before the Pay Commission for higher pay scale, but after the Pay Commission turned down the same, they have come forward with a different stand. The appellants cannot take conflicting stands, one before the Pay Commission and the other before the court. The Pay Commission's recommendations were not binding on the government. They ought to have taken a decision on merits. On this basis, the division bench gave directions as stated above. In our considered view, the division bench of the High Court was not right and justified in straightaway giving directions to grant pay scale to the respondent when there was no material placed before the court for comparison in order to apply the principle of equal pay for equal work between radio operators of CRPF and radio operators working in civil side of the Central Water Commission and the Directorate of, in the absence of material relating to other comparable employees as to the qualifications, etc., etc., etc. Now, Lordship kindly comes to C, precedent C. No doubt, the Directorate of CRPF made recommendations to the Pay Commission for giving higher scales on the basis of which claim is made by the respondent for grant of pay scale. The factual statements contained in the recommendation of a particular department alone cannot be considered per se proof of such things, or they cannot by themselves vouch for the correctness of the same. The same recommendation could not be taken as a recommendation made by the government. Even otherwise, a mere recommendation did not confer any right on the respondent to make such a claim for writ of mandamus. Or just one more, and I'll. This is in the context of the key law 300. GST Act recommendation, Lordship. GST Council's recommendation. 279 of the Constitution. Now, this is 2022. 2210 SCC 700. তুমি রাখো না পাশে রাখো না এটা ফেরত দাও তো ওকে এটা ফেরত দাও এটা পাশে হেল্প করুক পাচ্ছি তারপর দেখি দেখো এটা হেল্প নেই Paragraph 59. Page 777. This is similar to ours. Paragraph 59. The GST Council, which is a constitutional body, is entrusted with the duty to make page 777. Yes. The GST Council, which is a constitutional body, is entrusted with the duty to make recommendations on a wide range of areas concerning GST. The GST Council has plenary powers under 279A4H, where it could make recommendation on any other matter related to GST as the Council may decide. The GST Council has to arrive at its recommendations through harmonized deliberation between the federal units as provided in Clause 6 of Article 279A. Unlike the other provisions of the Constitution which provide that recommendations shall be made to the President or the Governor, Article 279A states that the recommendations shall be made to the Union and the states. The recommendation of the GST Council made under is non-qualified. That is, there is no explanation on the value of such a recommendation. Yet the notion that the recommendation of GST Council transform into legislation in and of themselves under 246A would be far-fetched. If the GST Council has intended to do a decision-making authority, to be a decision-making authority whose recommendations transform to legislation, such a qualification would have been included in 246A or 279A. Neither does Article 279A begin with a non-obstante clause, nor does 246A provide that the legislative power is subject to 279A. The Constitution employs the phrase consultation in certain contexts. For example, 323, that the Public Service Commission shall be consulted on matters relating to civil posts. 320 sub-rule 3 reads as follows. I'm not reading this out. 61. If the GST Council were intended to be a constitutional body whose recommendations transform into legislation without any intervening act, there would have been an express provision in 246A. 279A does not mandate tabling the recommendation in the legislature like the provisions Category 3, where the recommendations have to be mandatorily tabled in the legislature along with an explanatory note. Only the secondary legislation, which is framed based on the recommendations of the Council under the provisions of the CGST Act, IGST Act, is mandated to be tabled before the Houses of Parliament. The use of the phrase recommendations to the union or states indicates that the GST Council is a recommendatory body, aiding the government in enacting legislation on GST. In Manohar versus State of Maharashtra, a two-judge bench of this court, while interpreting Section 20, subsection 2 of the Right to Information Act, observed that the phrase recommendation must be interpreted in contradistinction to direction or mandate. It was observed as follows. We may notice that proviso to Section 20, subsection 1, specifically contemplates that before imposing the penalty contemplated under Section 21, the Commission shall give a reasonable opportunity of being heard to the officer concerned. However, there is no such specific provision in relation to matters 20, subsection 2 or 22 empowers the central or state commission, as the case may be at the time of deciding a complaint or appeal, for the reasons stated in the section, to recommend for disciplinary action to be taken against, says CPIU. Actually, I'm not troubling my lord with the quotation. But then let me show placetum just 2 lines below placetum A at page 779. It is page 779, placetum A, 2 lines below. It is a recommendation and not a mandate to conduct an inquiry. Recommendation must be seen in contradistinction to direction or mandate. But recommendation itself vests the delinquent public information officer or state public information officer with consequences which are of serious nature and can ultimately produce prejudicial results, including misconduct within the relevant service rules, and invite minor or major penalty. That's yes. Our case, central government has to accept it. In Naveen, it may fully reject it also. In Narayandas in Indurkia, a constitution bench observed that a recommendation has persuasive value. In this case, this court was dealing with the question of whether textbooks recommended by the board could be held to be in effect immediately. Lordship, I kindly come to paragraph 64. In numerous cases, the court has reiterated that recommendations cannot create binding and enforceable rights, in contradistinction to a direction or a mandate. So that is my point, my lord. It is today. It is not affecting anybody till it affects. Today, it can be at the highest a quasi-judicial decision, which you challenge as per the law of certiorari, where the hearing has taken place, or 227 something similar, where the hearing has taken place, where the order is made. At the highest, if a writ petition lies, I would say that, of course, writ petition does not lie, challenging it. You have to wait till the. And apropos this, Lordship may also keep in mind Rule 4, Sub-Rule D. What is the function of the designated authority? Rule 4D read with Rule 18. Sorry, Rule 17. 18 is the levy. Rule 4D is what is the function of the, it is a recommendation and function, and 17.2 is 17.1b is the recommendation on this, and 18 is the central government's levy after it doesn't even say, does it say after consideration the recommendation? There's no obligation that the recommendation has to be followed. Or should kindly see Rule 18. The central government may, within 3 months of the date of publication of the final findings, by the designated authority under Rule 17, imposed by notification upon importation, may impose. Any anti-dumping
time is mandatory, nothing. It may or may not.
May or may not. And
either within that period or outside that period, there is no bar also for accepting it beyond that period.
No, possibly they.
It is only limited.
Then maybe they have to do another study to find out the latest position. Rule 18.
Yes.
The central government may, within 3 months from the date of publication of the findings of final findings by the designated authority under Rule 1 imposed by notification. May impose. It doesn't even say after considering. Just there's a 3 months time period. And it says not exceeding the margin as provided in Rule 17. These are the two considerations.
So there is no consideration also.
No consideration. That's something, except that you know what is the maximum. That's all. So they have to get up-to-date position. So within 3 months, they must know what is.
Yes, very interesting.
Very interesting, Lord.
Central government may, within 3 months of the date of publication of final finding.
Upon consideration doesn't say.
No.
Now, Lordship also sees one thing, sub-rule 4. Sub-rule 4 is very important. If the final finding of the designated authority is negative.
I'll just come back on this. It is termed as final findings.
It is a quasi-judicial determination.
And it is termed as a final finding, not a recommendation.
Not a recommendation. Determine as to whether an article is being dumped on. Is a determination under Rule 17(1).
So determination is complete.
Determination.
Whether or not to levy is with the government. But whether it is being dumped or not, that part is complete.
That determination is complete as a quasi-judicial determination. But that will not affect him till the government gives levy of duty. So this, as I am saying, if at all, I am saying this is firstly, there has to be locus standi. You must be affected. A person affected can come. There may be a determination of municipal valuation of my property at 1 crore of rupees. But if there's no tax levied for that, it does not matter to me. I have no locus. That's my first point. You must be affected for it. Because Lordship also may see Rule 18, Sub-Rule 4. If there was a provisional levy, provisional duty under Rule 13, kindly see Sub-Rule 4. It may be undone. If the final finding of the designated authority is negative, so it may be 0. That is contrary to the evidence on whose central government shall be. So, sorry, that doesn't say leave.
So there is nothing more.
Nothing more.
So it is a ministerial act by the central government then. If there is no consideration, if you say, like there is no consideration, as rightly indicated.
So central government, then it becomes, as I said earlier.
But your point still survives that unless there is levy, there is no cause of action.
That's why I use the word policy decision. Then comes in many other factors, international trade, relation.
As you indicated, there is nothing to consider for the central government.
Except the maximum. Imposed by notification upon importation into India, the article covered by the final finding, anti-dumping duty not exceeding the margin of dumping as determined under Rule 17. So
how much figure it will levy, that is under consideration, not the levy in that case.
How much, whether to levy or not? And if so, how much to levy with that?
Whether to levy or not is also not there.
No, so may or may not. May means the central government may. Within 3 months of
the consideration may makes little sense in that case. If there is no consideration,
implied, I would say implied consideration, because there is, Lordship, may I read this entire sub-rule 1 first? The central government may, within 3 months from the date of the date of publication, within 3 months of the date of publication of final findings by the designated authority under Rule 17, imposed by notification in the official gazette, upon importation into India of the article covered by the final finding, anti-dumping duty not exceeding the margin of dumping as determined under Rule 17. So you must look at the final findings to see what is the That's what Jindal Polyfilm also said, which Mr. Sen has shown. It is not binding on the government. As I am saying, the only binding nature of this final finding is the anti-dumping duty. What is the anti-dumping margin? That is, central government can't cross that anti-dumping margin. Because the
So may is in reference to that margin only. To what extent it levy will
May is in deference to whether to
also.
May is in deference to whether to impose or not to impose, how much to impose, but the ceiling limit is the maximum, only to that extent.
May then whether or not to impose. And then the ceiling limit is the maximum, not exceeding that.
The Lordship, kindly see in this connection section 9 capital A by Junior rightly points out that the same provision is there in the Act. Section 9A of the Act. Where any article is exported by an exporter or producer from any country or territory, hereinafter in this section referred to as exporting country or territory to India, at less than its normal value, then upon the less than its normal value.
Yes.
Then upon the importation of such article into India, the central government may, by notification in the official gazette, impose anti-dumping duty not exceeding the margin of dumping in relation to such article. This margin of dumping is what the final finding decides. What is the margin of dumping? That is explanation A. The margin of dumping in relation to an article means the difference between its export price and its normal value. So if you are exporting at below the normal value, that means you are dumping the goods in India. And normal value is shown in C. In relation to an article means the comparable price in the ordinary course of trade for like article when destined for consumption in the exporting country or territory as determined in accordance with the rules made under subsection. When there are no sales of the like article in the ordinary course of trade in the domestic market of the exporting country, or when because of the particular market situation, low volume of sales in the domestic market, such sales is not permit, the normal value shall be either comparable representative price of the like article when exported from the exporting country to an appropriate third country, or the cost of production. For example, we can take the best example, BYD vehicles, the electric vehicles. If the cost of making, if China is selling BYD vehicles at $10,000 minus tax apart in China, and they export it at $8,000 to India, $2,000, they are under. That is the dumping margin. They want to capture the market here by dumping, by destroying the local industry, by local electric car industry. Or if they have no market in China at all, then they are exporting at $10,000 to Australia, Canada, Japan, but to India at $8,000. Why? They want to destroy the domestic market. They wanted to dump the goods. That is the normal way.
One clarification, this is section 9C. An appeal against the order of determination. This was what was previously there.
Now determination. So determination itself is appealable under the under this act, to the cessed act. Determination is appealable.
Previously, it was an order of determination which was appealed. Now it is the determination itself which is appealed.
A Jindal Polyflab has dealt with this aspect of the matter. Kindly take the Jindal Polyflab. ওটা আগের দিন দেখেছিলাম। তুমি দাওনি আগের দিন? ওই কপি দাওনি আগের দিন? Jindal what কি মেয়ে? এখানে আছে দেখি।
This amendment came into effect when?
Amendment came in.
The amendment came in on 1st of April 2024.
April 2024.
If I'm not wrong. Rajesh will correct me if I'm wrong.
April 2024. Then this. Can you just supply me, Mr. Sharma, with the objects of this amendment?
Very well. We will do that, Manoj. We will do that.
1st April with effect from 1st April 2024.
It actually came in the Finance Act when the budget was being presented. I think the date.
Notification, that notification
The
and
notification, Malad, and I'll put a small half a page note on this also. I will.
Yes, yes, yes.
Yes, I will.
So what net effect will be this? The determination without suffering any loss is made appealable under the statute. That's a peculiar right given under the statute to file appeal. Let's take it as order of determination. The word goes, order of goes. So Rule 17 determination is also appealable. So that is a special right given under the statute to cessed act. But that is not. That is why Lordship
was not previously there.
It was not previously there.
Now this is there.
So that is specially provided. That is why normally, kindly see, may I read out this section once? The word person aggrieved is not there. Kindly see this. An appeal against determination or review thereof shall be to the cessed act. Constituted under 129 of the custom.
That is
In respect of the existence, degree, and effect of any subsidy.
So anyone can prefer an appeal.
Anybody can prefer an appeal. So locus standi will not be there. But that is not the case of writ petition. Locus standi, anybody can prefer the appeal. That is a special right the statute creates. Without suffering loss, you may challenge that.
Mr. Mitra, you will conclude today. So I'll
I'll
release the original.
I have.
They are waiting.
Well,
No.
I have to go, my lord.
It's better. We are on the verge of conclusion.
But as I was saying, tomorrow, Lordship, is a full.
I am not too sure if they are not there. Their matter will not.
I can because we are not joining issues. You can join virtually also. I will finish my argument. You can join virtually. I can finish my
We
argument.
have no difficulties. Nobody has any difficulty.
Oh. Then in that case,
Tomorrow, otherwise.
It can't be taken. If anybody has any difficulty, then it can't be taken.
You concluded. Original side, or let the original side, other matters stand released. They are waiting. I'll take it up tomorrow. Tomorrow or day after, whenever it is, I'll take it up. And that Mr. Khaitan's matter is there immediately after this. That is 6 when. It was today itself. I know. That's why. Inform him that I'll not be taking up that. On the next day, I'll take up. And Mr. Yes. I'll take up your matter. Let Mr. Mitsu complete this. I'll be taking up either tomorrow or day after, whenever, whichever date. And Mr. Sharma will also be there. Yes, I need. Language was order of determination previously.
Yes, my lord, that has come on by the Finance Act 2023. I stand corrected, not 2024.
2023 Finance Act.
Yes, Finance Act 2023.
With effect from Mr. Sharma.
With effect from, my lord, it has not been notified as yet, is what my instructions are. But the stand of the Union of India is that it has got retrospective effect, for it will be applicable since the Finance Act has come in. That seems to be the interpretation given by the Union. But the
then it is
correct. So there is no formal notification, is what my instructions are.
Mr. Mukherjee, kindly hand over me or then proper this act. This act that has been made over to me.
But it's by the Finance Act and Section 2. That's Section 2 to 127 after. That's not correct.
Check up and also supply me a copy of these rules. And
I've already instructed Mr. Instructing Counsel's office to have the Finance Act copy to be sent to your Lordship's Courtmaster.
Because today it has not been notified.
Correct.
Then I have to follow the original version. And
although our contention, my lords, is the removal of the word doesn't make any difference in so far as the rights of the petitioner. That's a separate argument.
No, Mr. Mitra, you are just indicating that this is not any particular person aggrieved. This is an open-ended section where it says appeal against the order, even if I take it as order of determination shall lie to the custom itself.
In respect to the existence, degree, and effect of insubsidy.
What is the effect of the words order of determination and the determination separately? This has not been done without a cause. Certainly to achieve something, what was required to be achieved?
As I was telling my junior, he's very enthusiastic. I will go into that one. I will also go through that one.
I wanted that this clarification I wanted.
Yes, very important. I also.
See, if it makes a serious difference on this, then
it will be one connotation.
Something absolutely different.
I must look into it with maybe the
rest. You have all concluded, Mr. Mitra. Nothing more.
On the jurisdiction aspect.
Yes. Anything else?
And also that make money.
Yes, money. Yes, Mr. Sharma has. You want to place?
I want. But now I want to only show.
Yes, certainly.
That ONGC. Only the ONGC's case. Now, the suffering loss is repetition locus. ONG Utpal Basu. But suffering loss is a locus for writ petition. It is not necessary for this
section 9C.
9C is not
Different.
required.
You said
That's
that
statute
yes,
can always
even
create-
without suffering loss, one can prefer an appeal under 9C. Unlike in a writ petition. That you have said.
Unlike writ petition. Writ petition, loss has to be suffered. Paragraph মিলবে তো paragraph, আপনি paragraph টা আমি আমারটা খুলছি। Paragraphটা মেলাও। এই paragraphটা বল। Paragraph 5 টা বল। আমার paragraph 8 টা।
Paragraph?
I just because I had the
Yes.
I just compare the paragraph. The hearing. Yes, paragraph 4. At the hearing of this appeal, we indicated to counsel that we would like to confine ourselves to the preliminary objection of ONGC that the High Court of Calcutta had no jurisdiction to entertain, hear and dispose of the writ petition in the manner it did, as the averments in the writ petition, even if assumed to be correct, did not disclose that even a part of the cause of action for institution had arisen. The writ petition is averred in paragraph 43 of the petition that a part of the cause of action had arisen within the jurisdiction of the High Court as pleaded in paragraph. Next, they further averred in the paragraph, in the said paragraph, that they were likely to suffer a loss at its registered office within the jurisdiction of the Calcutta High Court if the contract was not awarded to them. And this is the averment Lordship will find on the basis of which the petition was filed. And the next paragraph, these are the averments in the body of the writ petition. Same paragraph, next page, 716. These are the averments in the body of the writ petition on the basis whereof NICO contended the part of the cause of action and arisen within the jurisdiction of the Calcutta High Court. It may also be mentioned that in course of submission before this court, counsel for NICO referred to a fax message in its I'm not going to the facts of the case. Now, Lordship kindly comes straight away. Paragraph 8 here.
Yes.
I need not.
Paragraph 8 that is the Times of India.
I'll come to that Swaika where they dealt with the
Yes,
Swaika. If I have 15 minutes. Paragraph 11. Paragraph.
The mere service of notice under section 52 to that part. That I have seen that. No, there is one more paragraph here where it considers this. Here it really proceeded on the premise that the petition did not disclose cause of action.
Within jurisdiction. That mere possibility to suffer a loss can never be a cause of action. And also that's
because
where
paragraph 8, last part, besides the fax message cannot constitute as conveying rejection of the offer as the fact occurred on 27 January 1993. Therefore, broadly speaking, NITCO claimed that a part of the cause of action arose in Calcutta because it became aware of the advertisement in Calcutta. It submitted a bid such and such. Those were scrutinized in Delhi, and that the final decision whether or not to award the contract to the tender would be taken at Delhi. Of course, the execution of the contract would be carried out such and such. Therefore, merely because advertisement in Calcutta submitted the offer would not, in our opinion, constitute cause of action. Because in a contract where the tender is accepted is the place where it confers jurisdiction or cause of action really arises.
And in
which is not the case here.
No. And in that context, you see paragraph. Yes.
Paragraph 11. Swaika, the decision took effect in notification in Delhi. That paragraph
But
11.
it said that, yes, that is why you should. But paragraph 11, it's that notice on the respondent's registered office did not confer jurisdiction, mere notice.
Here,
But
not
here
even
the
that.
effect is being felt within the jurisdiction.
Effect will be felt if it is levy is made.
That is
But
a
then you
different-
will suffer. Otherwise, this as a quasi-judicial determination, final finding, this has taken effect in Delhi. Unlike an order of injunction, for example, which may, till it is served, it does not take effect. This has taken effect upon the notification being published in
Yes. So here there is a notification of final determination. How can I ignore the notification? It takes effect the length and breadth of India, whichever is.
Final finding is.
Yes.
Like any order.
Final finding is also notified.
Say any order will have effect length and breadth of India.
But yes, but it has to be brought to the notice of that person. Here by the notification, it is deemed to have been brought to the notice. That is troubling me, Mr. Mitra. But
yes,
the other part of the argument is that yes, there is very much plausible because today there is no levy. And whenever there will be a levy, then that cause of action for
Like for example, state of Rajasthan, Swaika properties. Notification was in under the Urban Land Ceiling Act or some other act, yes, was in Rajasthan. It informed the world at large, all over, that the Calcutta person also that your property is there's some impact on you. But the order was completed there. If you look at it, say if you were exercising jurisdiction under Article 227 today, could the court have, because certiorari and 227 is very similar. That tribunal is not within your jurisdiction. It's a quasi-judicial final determination. Let's take it as that. Even if the effect, say a employee-employee dispute, there may be 4 plants. The service decision for the Common Administrative Tribunal Delhi will affect plants all over India. Rajasthan plant, Calcutta plant. But to challenge that decision, one will have to go to wherever that tribunal is situated, or the trial court tribunal, like in Kushubingarh, the first court or the appellate court. Because these orders like in 227. Otherwise, in a court where 227 and 226 is before the same judge, one can go, unlike our court.
Yes.
Now that will take me to make money. The last, though I will be very short on this because there, Sharma has dealt with this. This is a mere record. This confidential information under Rule 7, just make money. 2016 10S.
So do you refer to make money?
Make money. 1610S.
Yes. Which paragraph?
Paragraph, give me one.
On confidential information or on?
Only on confidential. Because that is one of the page 41. Paragraph 19. Looking at the contents of Rule 7 and the facts and issues involved in Reliance Industries, we agree with the submissions of Mr. Patil
that the fact situation in that case was entirely different and the court was not examining the provisions of Rule 7 in any detail, but made rather scathing observations against the DA because the DA claimed confidentiality not in respect of any information, but in respect of its own findings based upon the information supplied by the same party who was aggrieved by non-supply of the findings. The information is the observations in Reliance Industries case must be understood in the fact situation of that case in view of the well-established proposition of law that the ratio decidendi consists in the reasons formulated by the court for resolving an issue arising for determination and not in what may logically appear to flow from observations or non-issues. Reference in this regard may be made to the law enunciated on this point by a constitution bench in the Judge Krishna Consenso. Last, Placeter may F2 lines above. We are in agreement that Rule 7 does not postulate that the DA can claim confidence. There isn't the authority can claim confidentiality. And that too, not in respect of any information supplied by a party, but in respect of its reasons or findings derived from the information supplied by the very same party. Lordship, kindly see Rule 7. Rule 7, I can provide information marking it confidential. And then para 26. Yes, may I place that para 26 first? Page 44. We are in respectful agreement with the above view and also with the submission at the source of power in the DA to treat an information as confidential must be within the confines of Rule 7. The ordinary meaning of the words used in this rule is clear, and hence there is no requirement to depart from the golden rule of interpretation, that is the rule of literal construction. If the submission advanced on behalf of the Union of India and the DA are accepted, one will have to adopt a purposive liberal interpretation so as to enlarge the scope of this rule. That does not appear to be the intention of the statute makers, nor is it warranted by the context. The effect of Rule 7 is clear. It permits an exception to the principles of natural justice. In such a situation, even if there had been some ambiguity and requirement of resorting to interpretation, the proper course would be to adopt a construction which would least offend our sense of justice, as discussed and enunciated in Simpson. So it will be useful to remember that when two competing public interests are involved, like in the present case, and then 29 and 30 as the final findings of the court. In the light of the facts and submissions noted earlier, as well as the conclusions already recorded at various places, we are of the considered view that the question referred for our answer can be answered in a very straightforward manner by holding that Reliance Industries case did not go into the details of the relevant rules, including Rule 7, but the observation made therein in respect of rule of confidentiality as spelled out in Rule 7 of the rules do not diminish the scope of Rule 7 as provided. The reasons or findings cannot be equated with the information supplied by a party claiming confidentiality in respect thereto. Hence, Rule 7 does not empower the DA to claim any confidentiality in respect of reasons for its findings given against a party. The law laid down in respect of rule of confidentiality in Sterlite Industries case also has our respectful concurrence. But at the same time, we reiterate that Reliance Industries does not adversely affect or run counter to law. Par 30. We may only explain here that while dealing with objections or the case of the parties concerned, the DA must not disclose the information, which is already held by him to be confidential by duly accepting. How is it held? By duly accepting the claim, accepting such a claim of any of the parties providing the information. While taking precautions not to disclose the sensitive confidential information, the DA can, by adopting a sensible approach, indicate reasons on major issues so that the parties may in general terms have the knowledge as to why their case or objection has not been accepted in preference to a rival claim. But in the garb of unclaimed confidentiality, the DA cannot shirk from his responsibility to act fairly in quasi-judicial role and refuse to indicate reasons for its findings. The DA will do well to remember not to treat any information as confidential unless a claim of confidentiality has been made by any of the parties supplying the information. In cases where it is not possible to accept a claim of confidentiality, Rule 7 hardly leaves any option with it but to ignore such confidential information. If it is of the view that the information is really not confidential until the party concerned does not agree to its being made public. In such a situation, the information cannot be made public but has to be simply ignored and regarded as non-honest. So the decision, once claim is accepted, the DA cannot disclose that information, but his findings on the information has to be disclosed. Yeah. In Reliance was that findings were not being disclosed. In fact, the party who gave the information, the findings on that were not given to him, and the confidentiality was extended even to the findings and the reasons. So otherwise, Rule 7 is very clear. Very clear. Confidential, I claim a confidentiality and give it to the authority. I can't have it breached. If is not confidential, ignore it. But
you are also one of the parties?
Yes, I am also.
Claim any confidentiality?
Yes. I also claim confidentiality. On that term, I gave it.
I'll ask him to produce the records to that extent.
Yes, sir.
5 minutes you said, it's 5 minutes is there by the clock.
I will only might add a sentence on that amendment.
I would also like to be enlightened on
I will try to see if I can do some research. He's showing me something, but let me apply my mind to it.
No, but Mr. Sharma just said that it has not been notified as yet. I was not aware of this.
Achha? Is that true?
It is not. Malad, what the Act says, if you see that copy is being sent off, Malad.
Mr. Sharma, I have been made over on the first day is this set. So this has a compilation of the tariff. So I'll find out the.
No, a copy is sent to your lordships, Malad.
I have a copy of that.
Because the amendment itself says WEF Malad from 1995, from the date when the Finance Act was made.
Correct. This is with me, Mr.
Yes,
Sharma.
Malad.
It is already with me. I want to know something else. I am
amendment.
The amendment.
Yes, amendment only. The amendment, when the amendment was made by the Finance Act 2023, the legislature has put there that it would be applicable from 1995 onwards.
Kindly hand over the copy of the notification.
Yes, my lord. Somebody is sending it to your lordship's court master, my lord. In just about 5 minutes, it will be there, my lord.
Yes, sir. You start. I'll permit you to address on this later, not now.
I issue only 2 judgments, your lordship. Only one on the point of violation of national justice.
That will come later. Now you
tell
me. You have received this.
Yes, we have received it.
That email we have.
No. Page 225, we have received this. Kindly come to page 225.
Here. 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 Yes, your lordship, we have
From DSK Legal, that is their advocate on record.
your lordship. It has been received.
You have not responded to this.
Your lordship, no, because there is confidentiality clause.
Where is that
Number two.
confidentiality?
Your lordship, the section is
Where
already.
is that confidentiality?
That I'll read out.
Who has
Your lordship.
claimed? You are giving
No,
confidentiality.
it's in the disclosure. These points have been explained in the.
No, where is that letter? You have to show me those documents. And the court is entitled to see whether someone has claimed confidentiality or not, and to what extent.
That
I've
document
indicated on the last occasion. Mr. Sharma has disclosed one document. I've indicated on the last occasion.
That
Take
we have
instructions on this.
told you
Bring
about.
all letters on confidentiality what you have in original. Before
No, that
this
I
court.
didn't get, your lordship.
It's not recorded in the order. I will record in the
Your
order.
Your lordship, then
How soon can you bring it? Tell me.
at least 1 week, your lordship. Because this
1 week. What were you doing so long?
Because the emails are there.
How many documents have been issued to you on confidentiality? Bundles.
But we have to also provide the supporting documents, my lord. Just only the letters will not suffice.
What
Invoices
support? I
are
am not
there.
insisting for disclosure of all documents, Mr.
On only the emails.
What extent they have sought for confidentiality? What they have claimed to be confidential?
Your lordship.
In that those particular documents.
Your lordship.
What you have in your custody?
Your lordship. Give me 7 days.
No, not 7 days. Bring copies of those documents via email from your office. It is not so difficult for you to bring it. Matter is pending for more than a month now. First, I had taken up copy. Hey, order sheet. I had taken up this matter on 3rd of March 2025.
Your lordship specifically asked me to confirm that whether the Mr. Sharma's client's email was received or not.
When you wish to come back, because I'll give you opportunity to respond because you did not start. I'll ask him for those confidential documents, whatever are there with him, and then I'll give you opportunity to respond.
My only difficulty is, from this after Friday, I will not be available till the 31st.
Thursday concluded.
The 30th.
Thursday concluded.
Yes, I can, my lord.
Original side has covered the entire last week, this week as well. So finish it off on Thursday.
If they bring it, my lord, I'll do it.
Your lordship, right now, he will confirm. Maybe it can.
Mr. Sharma had disclosed this. You need a formal order. You ought to have told me on the last occasion.
That is already confirmed. I have the letter with me.
My lord, we can do it tomorrow.
Yes, your lordship, I have that.
Yes. If everyone is there, I can hear you.
Yes,
No.
My lord, it's not an output. It is, my lord, no adverse order.
So if everyone is there, I'll do it.
If tomorrow afternoon, my lord, I've just fixed another matter in the morning because these are the best opportunities.
Yes.
My lord, if both sides agreeable, my lord, we'll go.
Can you bring that tomorrow?
Oh, yes. Your lordship. Yes, I have received one surrender. There are others. In respect of one, yes, I am giving a copy to me.
No, it's a communication saying this is confidential.
I don't know. What are you handing over your hand?
This is the one which Mr. Sharma relied.
Yes.
So he's received.
Yes.
আমার 3 নাগাদ বেরোতে পারি আড়াইটের সময় আমার 2 থেকে 3:30
So this is the only document?
As yet, if your lordship.
No, you hand, I'm not asking you whatever you have on.
Yes, this is
the only document available with you on confidentiality. I take it.
and our other invoices are there.
Invoice is not necessary for disclosure.
Up to this point.
So this is the only document that you have received.
So far.
I'll record it, sir.
So far, he has not
No,
got
what
the.
so far? You can't improve today. Today you can't receive any other document.
No. If he had got it, he has got the full instructions very clear.
Yes. That I received your lordship.
Ascertain this and come back
Ascertain,
tomorrow.
come back tomorrow.
I'll not record it today.
Check for
Ascertain
the-
this and come back tomorrow. This as a consequence, please understand.
Your lordship, may I explain? May I explain the situation? Just 1 minute.
You come tomorrow. Tomorrow you will not be here.
Tomorrow I have some problem with hypertension and I have to go to the hospital. My and how long it will take over there, I am not certain about it.
How long will you take, Mr.
My lord, your lordship will have queries. My learned friend.
How long? Yes, certainly.
Yes. So
how
my
long will you take? No, I want to conclude this on this side.
Yes. So my lord, what I am saying is subject to my lord.
If it is not available tomorrow, I'll not take it up tomorrow because
kindly take it up.
No, I'll take it up on Wednesday, on Thursday at 2. You come at 2 and finish it.
Thursday 2, I can't, my lord. I have division benches fixed. That's why I was praying to God, my lord, that everybody would agree on this. And my lord, I can keep my lord.
Here tomorrow in that case.
Your lordship.
Please understand the difficulty is.
Your lordship fix it.
Yes, tomorrow. Tomorrow at 2.
2, fine. Fine, my lord. 2 o'clock.
But your lordship, my presence may not be required. My presence may not be required. We can.
No. Yes. Someone is there. Yes.
He will be there.
Whosoever. Sir, I want all the parties to be represented. I'm
your lordship.
Individually for an advocate.
Your lordship.
So long the parties.
Obviously.
All the parties are here. I'll take.
Obviously. Your lordship.
Tomorrow at 2.
Yes.
Kindly.
Yes, if there is any other document they have received.
The document suggests that it's the only document. No. It says so, para 2, that this is the only document.
Your lordship, just one second.
May I just clarify that aspect, my lord? The documents, as in the invoices.
Tomorrow, Mr. Sharma, it's already 4:30.
Very.
From 2, I'll take up these matters. So comment.
Yes.
Just 2 pages of.
Yeah.
I'll just.
Tomorrow. Oh, you'll not be here. Yes, continue.
Just 2 pages. 2 pages. Delhi High Court judgments of division bench.
Judgment he will place tomorrow. Mr. Dudoria will place. Any document you want to place?
All right.
Any document?
No, not now.
Follow.
Tomorrow at 2.
Take a chance. Tomorrow there is an assigned matter fixed. So if it is there,
usual, my lord. Otherwise, your lordship, my lord, kindly, my lord, divide the time.
Yes. No, it's already fixed.
No, that's okay. So divide, my lord.
I'll also fix it after that matter.
Yes. No problem.
Because it's already fixed.
No, I'll be there.
So if both parties are not there, I'll take up your matter. Take your chance. If they are there, after it is concluded, then I'll take it up.
Yes.
It will not continue that long.
Yes.
Maximum half an hour.
Yes, my lord, no problem.
But I'll do it at 2:15. So it will 2:30. It'll be easier for you.
Very well.
So, ওটাও ফিক্স আছে 2:45 ফিক্স আছে দুটো সময় থাক it's fixed. No, it's fixed at 2:45.
Yes, my lord, I'll be here at 2, my lord. My lord, that also suits, my lord, Mr. Mitro, discussing, my lord. No, that they can go to, my lord. He can do 2 matters. I can only do 1.
No, today's matter, I was told by my juniors.
Spill it over till tomorrow. I had insisted that he completed today. And he has
but tomorrow he has 2. So
No.
Take 2 p.m. so that I can do this.
Because this
as well as another
same matter has been kept at 2:30 tomorrow because I couldn't make it.
So it's easy.
I may take 5 minutes because of this on the amendment. 5 minutes.
That I'll give you opportunity to respond even after
Very
Mr. Mukherjee completes because that is on a legal issue. I'm sure he will not object.
Notification, my lord, no
Yes,
problem.
notification and what is the present whether that amendment has been given effect to or not, and what object was sought to be. Please also answer.
Yes, sir, I'll be answering that.
What object was sought to be?
I'll be answering that, And my lord,
Because the judgments were rendered all prior
to the amendment.
all of
Correct.
So I want to
And
understand.
my lord, I'll also show your lordship, my lord, the central government stand after the amendment.
Your lordship, let it be recorded about this document.
Yes, yes. আগের দিন নেই আগের দিনে অর্ডার শিটটা দাও এই অর্ডার শিটটা কোথায় আছে Your name is recorded on the previous. Mr. Mitro, learned senior advocate representing the respondent number 5, and Mr. Bhattacharya, learned advocate representing Union of India. Mr. Bhattacharya has also placed before this court a photocopy of the communication dated 7th of February 2025. He received from
I take my lord.
one of the domestic industry. Yes, one of the domestic industry. On the issue of confidentiality as provided for in section in rule 7 of the customs tariff within bracket identification, assessment and collection of anti-dumping duty and dumped articles and for determination of injury bracket rules 1999. There are no other documents. That will answer tomorrow.
That I'll answer to.
Submit that as to whether the designated authority had received any other document from any other domestic inquiry. Now, he would submit that he would take instructions as to whether the designated authority had received any other document from any other domestic industry in connection with the above confidentiality clause.
Yeah.
I mean, this matter for further consideration under the same heading. I'll be deep to David. Get it out 2 p.m.
Oh, bless you.
You'll be there.
Yes, I will.
And kindly address me on that amendment. That's very important.
Yes, I will.
Effect, impact, and if you have, I'll try to also bring in the rules, the previous rules, notified rules. These are photocopies of
the official gazette.
If you have it, yes, it will be very good. I'll try to find out from the. I'll try to find out from the judges' library also.
Your lordship.
এইটা এখানে আছে ইন্ডিয়া নাও এর মধ্যে আছে
Your lordship, I'll come tomorrow, but kindly, your lordship, I have only 2-3 minutes time to show a couple of judgments.
Yes,
Your lordship.
I'll allow Mr. Dudoria also.
Your lordship.
Mr. Sharma, your matter was adjourned because this matter was continuing. Mr. Khaitan was here.
Oh, okay.
Your matter would be taken up on the next available date. If you're there tomorrow, I can take it up tomorrow. If you're not there tomorrow, on the next available date when you want to be there. I know.